Hello, everybody. The time is 9:30 and the inquiry is resumed. Okay, so today, looking at my schedule, what we have is Section 106 discussion and then closings. And then if people want to pick up any issues on conditions or anything else, then we can maybe look at that as well as part of the Section 106. In terms of other preliminary matters, I just wanted to check the ID documents that I have listed, just to see if that accords with your lists. So when we last checked this, we got as far as the Burston Nurseries appeal decision and the inspector site visit route. Since then, I've also added the climate change SPD, the natural environment SPD, and the CCG's letter. They're dated 2nd of February. Is there anything else that we think needs to be added?
Not at this stage from us, no. It might be at the end of this session that we're about to have now, but at the moment, no, sir.
Okay. And I think that's...
I think Miss James is... Yeah, sorry.
I'm sorry. Did you say you'd got the planning obligations SPD as well? I'm just thinking
no.
that it was one of the documents that was sent in initially when the appeal was registered. I don't know if it made it onto the core document list. It's with you. It is with you. It's just I don't think it's on the core document list, but we can arrange for that. Either. No, I think we can arrange for you to get a copy. I'm sure Eve will forward you one.
Okay, shall we do that then as an ID doc, and if you can get that?
I think so. Yes. Yeah. Thank you.
Okay, thank you. I did have and I have read the still compliance statement. The county council supporting statement, and obviously I've now also read the CCG letter as well as of course the 106 itself. So that I have those. Those are the documents I have open in front of me now ahead of this roundtable session.
Document that's literally just been sent about 4 minutes ago from Active Land Management, healthcare provisions.
Yes, that's what I said, but there might be more at the end of the next session. That's what I meant. No, what I think what we'll do, because when we come to the 106 session, so I'll talk you through we'll get there in a moment. But that's what I said, that there might be a couple of extra bits to add once we're done with the next session.
Okay, and actually I'm looking at my emails as we speak. Emails are coming through. Let's deal with these. I have a hydrants required letter. This is coming from council.
Okay. This must relate to that condition.
Been emailed to me. Yes, Mrs. James.
Sorry, sir. Yes, we had a few loose ends, I think, with regards to conditions 12 and 15. So, I think it's quite self-explanatory. Obviously, it's there for all parties to consider.
Okay, and has this been CC'd to all parties? Sorry, I'm just looking.
Yes, it has. Yes, it has. Yeah, I've done it.
That's the one with. Is that the one from Miss James with some comments on 12 and then 15?
Yeah.
The email?
It just gives you a greater clarification on where the EHO was when he required, an updated NIA. And they're just his comments that he's reiterated as to why that condition has come about. Right. The fire authority, they didn't comment. You were right. They didn't comment initially. However, they usually do. And retrospectively, now that they've supplied a comment, and that's attached.
Okay.
I'm happy to accept that if Mr. Simons is.
Certainly, happy for you to accept it. Yeah. Just trying to work out how it. I mean, in some ways, they're both quite kind of. I don't know about narrow points, but they're sort of they're points. I'm happy if you like for you to sort of just take away. I mean, you've heard the back and forth on those two conditions. Very helpful to Mr. Thank you, Mr. James, for doing some further digging and leave it with you. I mean, I'm not sure whether or not on the back of all that stuff, you'll reach a view that there is indeed a necessity for either a noise condition or a hydrants condition, but I'm happy to leave it with you to reach your own judgment.
Okay, I think what I'll do is we'll have a break after the 106 session before we come to closings, and I'll read this properly then. And if I have any questions, I can ask them at that point. But I suspect I won't, and it'll just be something I take on board when I make my decision.
Understood.
So before we move on to section 106, there's one very small factual update.
Okay.
I'm not sure you want to hear it now or.
Yes, now.
Yeah. A very short point. So you recall there was some talk about the Clare House Stables site, which the council relied upon because the size was different to what the ASA said it was. And you recall that Miss James's evidence was that nothing had been heard and the permission was due to lapse on the 5th of February, which would be tomorrow. Yeah. As a matter of fact, a reserved matters application was validated by the council either Monday or Tuesday this week.
That keeps it alive. Is that right? Sorry.
Yeah, I presume then it doesn't lapse because it's been. Yeah.
It won't lapse.
Yeah.
It would have lapsed if the RMs hadn't gone in time.
Correct.
But they squeaked it.
Okay, I can add that to my notes from that session then on the status of that site. Thank you for that information. Thank you. And I've just seen, I think this is what Dr. Keith was just referring to. I've had another email through here with some healthcare.
Yeah, they were actually amazingly given. We've all been, as you can imagine, since the CCG letter, we've been in a bit of a, we've been going back and forth with our legal team, who one of whom you'll meet in a moment. And so actually the first email that was sent this morning can be disregarded because even since that, we've refined it further, found some more support in other cases, other appeal decisions. And so as Mr. Mehta will explain, it's actually the second of the two emails that you'll need when we get to explaining what the healthcare provisions are. What the intention is when we get to the 106 session in just a moment, that I'm going to ask Mr. Mehta to actually just talk you through this and explain how it all relates to the CCG letter so that you can understand it. Of course, then what we might need to do is, who knows, you obviously you can ask us any questions you've got. You might want to take a break to properly consider it after that and come back with any further questions before we close. But we would have done it sooner, obviously. Really sorry about that. It's just a reflection. I know Dr. Keith has, and us have been banging the drum with the CCG for donkey's years. So it's not about that. It's just that, as you know, literally it came in when it came in, and so it's all a little bit end of the process. But anyway, all will be explained. So I wonder whether the easiest thing when we get them up, we'll just talk you through what there is there. You can reach a view on, how easy or difficult you think it is and questions you've got on it. And then obviously if you want to break to think further about it before closings, and obviously that's we could do that. Okay,
I think that's probably the best way. We talk it through, but it might be that we have a break and then another quick 106 roundtable session after that, just to firm that up. And yes, I understand the lateness of this, and it's not the fault of anyone in the room. It's the CG, isn't it? So and I do understand why we are where we are. Okay, thank you. So that's everything I've got in terms of extra information. Is there anything else anyone wants to raise before we turn to the section 106 discussion?
Not us, sir, other than just to introduce who, when we get there, to introduce who'll be speaking for us. I hope he's on the line now. I can't see his camera on yet. I'm hoping he's going to appear magically in a moment. Yes, there he is. It's Mr. J. Mehta, who's a partner at Howes Percival LLP, is the man with the plan for the 106. So he'll be addressing you on what's in it. And what one sees, we'll do the idea, so as you'll see, the main bulk of the 106, the bit that's already done, if you like, and agreed. And then there's a separate document for now. There's the healthcare provisions that we'll look at separately. And then, of course, in due course, depending on what on your reaction to it and all the rest of it, that will then end up in the final 106 that you get within 2 weeks. That's the idea. So yeah, Mr. Mehta's here for us.
Okay, thank you. And if I could turn to Mr. Smythe, just for who's appearing from your side.
Ooh.
Have you just disappeared?
I think he might have just disappeared, so I've only just noticed.
Okay, then we'll wait a moment for that to resolve itself in itself.
Yeah.
I suppose, is that other gentleman I can see on the line? Are you the council representative?
Yes, yeah, my name's Russell Wignall. I'm the legal assistant for the council, and I've been doing the 106 with Jay. So
is that what's your formal title for the report?
Legal assistant. Do you need my qualifications as well, sir? Or
yes, please.
Okay, so I am a graduate member of Silex, which is now known as a advanced paralegal, as I've just done a shake-up on the various membership grades.
Okay, thank you. And do you work directly for the council?
I do, yes. In-house legal team.
Okay. And Mr. Mehta, are there any qualifications I need to put after your name?
No, just Jay Mehta, sir. I'm a partner at House Percival.
Thank you.
Thank you.
Yes, we do need Mr. Smythe on the line. Oh, there we go.
Promising beep.
And as we're talking about this, so you were talking about there being 2 emails. So this has all been coming in as we're speaking. So is it the one which also appealed to a Stoke Golding appeal decision? Is that the relevant?
Let me just see, sir. The email that now I think that there are 2. The first one had an appeal, one appeal decision. The second one should have had the one that you need has a Word document with some healthcare provisions.
Yeah,
Mr. Mehta will speak to, and then on the same email there should be, I think, 4 decisions PDFs. So not just 1 or 2, but 4. There should be
PDFs, but I haven't opened them yet to see what they are.
No, that's fine. So if you've got a single email with 1 Word doc on the same email with 1 Word doc and 4 PDFs, I think that's the right one.
Okay. Yes, I've got that. Thank you.
Now, hopefully, in due course, Dr. Keith and Mr. Smard never know. I think it's been generally pinged around. So, as I say, when we get to that bit in the process, Mr. Mehta will talk you through what it all actually is. We can take it from there.
Okay, thank you. Mr. Smythe, you dropped out then. I'm not sure how much you missed.
Yes, so I'm sorry for that. Don't worry.
Okay.
You carry on. So I'm sorry about that, sir.
Thank you. All I've done really is just talk a bit more about those emails and also taken the names of the people represented at the roundtable session. Okay, so should we go into the roundtable session? I mean, I know we're going to talk about the CCG stuff in detail, but in terms of general agenda, did we just want to take my track changed version of the 106 and just go through it page by page?
Agreed.
Okay. And obviously, if at any point you want to shout out about something which you think needs to be talked about that I haven't raised, then please do so. Okay. So what I think my first comment isn't actually until page 5. Where I questioned the use of maximum possible number of affordable housing units for the reasons set out in my text. So I thought we could talk that through.
Thank you, sir. Shall I address the point first and then perhaps hand over to Mr. Wignall on behalf of the council? So the intention of this provision, sir, is the intention to ensure, as the text suggests, the maximum number of affordable housing units to be provided on site. Once we've quantified the number of affordable housing units that needs to be provided as part of this scheme. Speaking to Mr. Wignall, although he will address you separately, sir, we're quite comfortable that the affordable housing in terms of design, mix, etc., can be adequately controlled at reserve matters stage. So the intention of the section 106 here, and by reference to the maximum number, is really the intention between the parties that we will try, subject to, of course, design, mix, etc., to get the maximum number of on-site provision before then defaulting to the off-site financial contribution in lieu.
Okay, so that's really what the focus of this is. It's about the on-site versus off-site.
Exactly. Yes, sir.
Okay.
Yes, and if I may say, I completely echo Mr. Mehta's points there. It's something that we feel can be dealt with at reserve matters. It's just about trying to make sure that we get the maximum number of good quality affordable houses on the site, rather than just picking an arbitrary number, forcing them in and sacrificing design standards for the sake of having a full number. Obviously, from a council point of view, we want to have as many affordable units on site as possible, but there is the balance to strike between affordable units and quality affordable units. So I think it is sort of felt that we can deal with the mix, the sizes, the tenure mix, etc., as part of the reserve matter application.
Okay. All right, thank you. That's a clear explanation. So thank you for that. And I'm happy to strike out my comments on that then. Thank you. And then I'll make another comment here. Let me just read it through in case it's just been answered on the next definition. Yes, this is potentially still a relevant question. So again, I'll maybe turn over to Mr. Meta on my first comment there under affordable housing units.
Yeah, thank you, sir. So the definition of affordable housing units and the reference to no less than 30% of the housing with care units is simply the formula for the developer and the council to utilise to decide how many affordable housing units should be provided on site. So for example, 170 units, which I believe has been in the application documents, that would generate a need for 51 affordable housing units under that formula. And then of course, under the affordable housing scheme. So as we've just discussed, through reserve matters, we'll decide how many of those can be provided on site on the affordable housing land, and then separately how many of those are subject to the financial contribution in view. So this is just the mechanism to establish how many affordable housing units need to be provided either on site or alternatively in lieu by way of a financial contribution.
Okay. And Mr. Wignall, is that something that you're comfortable with as well?
Yes, sir. As a council, we would normally do 30% or a percentage of the final number of dwellings. We wouldn't normally do a percentage of floor space. So that's just how we tend to work out affordable housing units as a percentage of the rest of the units on the development.
Okay, thank you. Again, it's a clear explanation, and I'm happy just to strike through my comments and leave it as written. So the next comment within here is really a comment about something else, but it's just the first time that the word care home came up, so that's why I put it in there. And this is about, do we need to define care home stroke extra care with reference to schedule part 4 of schedule 2 because of its importance to the appellant's argument about the offer, or as I put in my text there, is it simply the nature of what's proposed that controls it? And it doesn't really need to be controlled in wording in a 106. So again, just something I think just wanted us to talk through. I don't mind again starting with you, Mr. Meta.
No, thank you, sir. So I think there's perhaps two points here in terms of the definition of affordable housing units. It is perhaps superfluous to refer to a care home because, of course, this is an extra care scheme. But that is simply to make sure that the parties are clear that effectively the affordable housing percentage, a number of affordable housing units, only applies to dwellings following the Rectory Homes decision. So for the purpose of the definition of affordable housing units, reference to a care home is perhaps superfluous, but equally, I think Russell and I and the council and I are content to leave that remain, or alternatively, so if you prefer, we can delete. In terms of the schedule and the occupancy restrictions, I think that if we have a planning condition, which I believe we have, sir, that effectively controls this development as an extra care scheme pursuant to C2, then I don't consider there's a need for any further restrictions or indeed definitions in the section 106. And when Mr. Wignall and I talked about this yesterday, we're quite comfortable to leave the schedule in part 4 of the schedule remaining in the section 106 agreement as it currently stands. We do have a definition of extra care, which, as you pointed out, sir, is vague, but deliberately so, because extra care can encompass a whole range of things and services. So we're quite comfortable with the definition. I don't think a definition is actually strictly necessary because we have planning conditions that ordinarily restrict a scheme to extra care. under C2, but we've just included it in the Section 106 agreement to provide some parameters, albeit they are vague for deliberate reasons. So I'll let Mr. Wignall respond to that, but I don't think there is any further need of any further controls or obligations in the Section 106 or planning conditions over and above what we already have, sir.
Okay, so this is condition 28, isn't it? So the development hereby approved, with the exception of people housing, shall only be used for the provision of extra care housing purposes falling within use class C2. So you're right, it does explicitly state extra care there. So let me just think this through. So you've got extra care explicitly stated in 28, condition 28. And then housing with care units. Do you mind just give me a second just to reread this now, just to make sure I'm comfortable with it. Okay, I mean, it does refer to extra care again, and you've just explained why it's vague, which I agree with. I don't think we want to be putting in arbitrary controls here. And I think there is a little bit more information on ages, isn't there? So that's probably the purpose of this. It goes beyond the condition.
Yes, agreed, sir.
Okay, Mr. Wignall, are you comfortable with everything we've just discussed?
Yes, thank you, sir. Yeah, I mean, in regards to the affordable housing unit definition and the care home side of things, I think this is a fairly unusual scheme in many ways. It's just trying to make sure we have the definition properly defined, that if it's a care home, it would be you wouldn't be able to have affordable units based on the number of rooms in a care home, but if they're separate dwellings, you'd have a percentage of those separate dwellings, albeit those dwellings are housing with care or extra care facilities. And in regards to keeping the schedule, yes, we prefer to have it in the 106 just because it creates a better longevity from an enforceability point of view. Obviously conditions can be breached, whereas 106 just gives the council that a little bit more long-term enforceability. And I think that it's defined in a way to keep it vague enough to not unnecessarily restrict occupation, but closed enough to make sure that it's a certain type, certain class of people that would qualify for these housing with care dwellings.
So what I'm a little bit concerned of now, just rereading it again now we've talked this through, is the fact that there's this, so going back to the affordable housing units definition, the fact that there's this bracket, which essentially is an exception clause saying, as long as it's extra care, not a care home. But do we want a clause in there saying that it might possibly be a care home when actually it won't be?
I think so. In response to that, we could probably, and I think we should, given the conditions and of course the nature of this scheme, that we can actually remove and or is not a unit of occupation within a care home. I think we can exclude that wording because by reference to the conditions, the nature of the scheme, the description of development, this is an extra care scheme. And actually that wording is probably on reflection superfluous because the main point is providing the housing with care unit is a dwelling. And I think that then chimes with rectory homes and what we're trying to achieve here in terms of the carve out.
Okay, I think I would be more comfortable if that was deleted, if that's okay with council as well.
Yep, that's fine by me, sir. Thank you.
Okay, so I think subject to just deleting that and or section, I think that I'm comfortable with that now. Okay, thank you. So if we just turn over the pages. This description of development. Do they all marry?
If I may, sir, I've spotted a late typo.
Okay.
First open bracket, it says compromising up to 30%. I think that should probably read comprising. It does say compromising on the planning portal as well. So it's one of those that how many people need to look at it before it's picked up kind of thing. But I think that should probably be comprising.
Yes.
Needless to say, agreed.
Yeah. Okay. Okay, fine. Thank you. Turning over the page. Yes, there are no market housing units. Do we need to refer to them at all? This is the first of several references.
It is so, if I may. I don't believe a representative from County Council is here at the moment, but and obviously I'll let Mr. Wignall speak, but Mr. Wignall and I have spoken to County. This was an addition from County Council's legal representative. We have done a couple of laps on this behind the scenes in terms of, you're absolutely right, so there are no market housing units. Either it's extra care, which fall within the definition of housing with care units, or alternatively affordable units. But for completeness, if I can put it like that, County Council's legal representative was keen to retain the wording just in case market housing units did come forward in the future, so that the Section 106 agreement bound. Now, I'm personally of the view, and I'll let Mr. Wignall respond, but I'm personally of the view that this is superfluous. The Planning Commission itself would not permit market housing units unless, of course, it's affordable housing units or indeed the housing with care. So I don't think we will have a situation through reserved matters or otherwise where market housing units will be provided in the way that's envisaged.
The only way that you get market housing on this is Section 73, and at that point you'd redraft to Section 106, wouldn't you?
Yes, quite. Absolutely, sir. Even if that was permitted within the scope of the planning consent, I think ultimately there would be an opportunity to revisit this. Having said that, if I can be frank, it's not a point that I'm overly concerned about, because at the end of the day, if no market housing units are to be provided, then ultimately that reference will never be enacted and never come into force.
Yes, Mr. Wignall.
Yes, thank you, sir. I mean, I broadly agree with Jay, sorry, Mr. Mehta, that it was a county council suggestion. I think it's because their education triggers rely on market housing and affordable dwellings. So I think they wanted that in there in case market housing ever came forward, and as such their triggers would be affected. Obviously it's difficult for me to speak on behalf of the county council, but like Mr. Mehta, I have no great qualms leaving it in. If nothing comes forward, it will never be enacted. I suppose one small advantage is that if there was to be a Section 73, you might be able to get away of not having to redraft a 106 because you could. This is already in there, but I mean it's marginal. I'm to be honest, sir, I'm happy to be led by you on this.
I just think it's redundant. I don't think it causes any issues as such, but it just doesn't seem to be necessary either.
Sorry, I'm just sort of jumping in. Apologies, I was late. My name's Stuart Clark. I'm a principal town planner at the County Council.
Okay.
So apologies for joining late. I mean, the way the matter has been described is the way that it is. It does relate to the education contributions having different child yield multipliers, but I do understand and recognise the point that if there is no market housing, then therefore if there were to be an amendment to the scheme, then due process would follow and there would be a deed of variation. So I would agree that whilst it is a belt and braces approach by a legal representative, I think, yes, we are quite happy to leave that to your judgment as to whether it needs to be included or not. Okay,
thank you. So just can I take are there any, Mr. Clark, are there any professional qualifications I should add for the notes?
Yes, I am MRTPI.
Okay, thank you. In that case, I think I would prefer to remove the references to market housing units, just because I think they are redundant. And if the scheme changed to the extent that they were included, then you would definitely be having a deed of variation on to change other things as well. And you could just mop it up at that time. Okay, thank you. And that we'll just take that as read for the rest of the document,
okay,
rather than keep them raising the same point again.
Yeah, thank you, sir.
So if we just turn over the pages. Yes, monitoring. Every 106 I do, the council and the appellant agree to a monitoring fee, and they don't mind. PINs, in terms of our own internal procedures, are quite difficult about this. And it's such a small amount of money, and it seems like I'm being pernickety, but it's just something which we constantly raise. Now, did anyone want to jump in on this case law that I've highlighted there? I suppose to justify the monitoring fee.
I think, well, perhaps I'm happy to let county speak to this topic first, so if they would like. Otherwise, I'm very happy to jump in and offer the thoughts on behalf of the appellant.
Well, yes. So just insofar as the county monitoring fee, I mean, you know, this is something that we've always thought for a number of years, and it just represents the work that the monitoring officer does in just making sure we have the timely payment of the contribution. It is something that was identified in our draft planning obligation strategy. And originally it was based on the complexity and the number of triggers, but it's since been just simplified to a standard fee, you know, that we charge and you know, normally is paid without question. I'm afraid I haven't seen the case law aspect that you've highlighted, so I'll perhaps pass that.
I mean, before working as an inspector, obviously I used to work both private and as local authority planning officer, and I'm aware that monitoring fees are just things which are just agreed to by both sides without really thinking about it. It's only pins that are difficult about it. Yeah, so the case law essentially was raising questions about its compliance with Reg 122 of the SIL regs, and whether or not it is strictly linked to the proposal, and therefore whether it passes those regs tests, i.e. is it necessary to make development acceptable in planning terms.
Well, I suppose, you know, we would be arguing that the timely payment of the contributions is necessary to ensure that the mitigation is in place as and when it is required. So yes.
If I could perhaps add my thoughts, sir. I think my understanding of Oxfordshire, essentially the contribution has got to be justified. So I think Oxfordshire did say that in certain circumstances where the contributions are justified, etc., they could meet the relevant legal tests under 122. If this was a significant sum of money, then perhaps in the usual course of events we would be asking the county council to justify the contribution in terms of breakdown of costings, hours spent monitoring, all of those sorts of things. But given the relatively nominal sum, sir, and obviously it's a matter for your judgment, but I would suggest that it perhaps is reasonable, given the relative nominal sum in the circumstances. But of course, sir, if you're not satisfied that monitoring is required, and you're not satisfied that the payment of the monitoring fee is necessary to enable the grant of planning consent, then we've got the usual blue pencil clause in the Section 106 agreement at paragraph 4.2.
So just to add to what Mr. Metters said, could I just give you a paragraph reference in the PPG
Yes.
on planning obligations? The PPG on planning obligations, and the para that I want to just want you to be aware of is paragraph 36, paragraph 036. I won't give you the full enormously long reference. So it's para 036 of that PPG, and the key thing to just note about it is that the revision date on it was September 2019, so relatively recently. And it confirms what central government's telling us about the position on monitoring fees, which is to say that they can be used, monitoring fees can be charged, if you like, through 106 obligations. They've got to be proportionate, they've got to be reasonable, they've got to reflect the actual cost of monitoring, but that's a useful reference.
Okay, thank you. I mean, given the cost here is nominal, I'm happy to leave this in, and I'll, you know, if I am writing this up to be allowed, I'll find a way to justify it in my report. So yeah, let's just leave it in. It's not like you sometimes get with London councils when it can be quite extensive costs. Okay, thank you. Turning over the pages. So yes, I've made that comment on tenure mix, which I think is self-explanatory. Again, perhaps if I just start with Mr. Mehta, just for your comments on that. So this is page 13.
Yeah. So I think, sir, this is the same comment from my perspective as we dealt with earlier in the context of affordable housing units, that ultimately the mix, design, size of the units will be agreed through reserve matters stage. So even though in this instance we've got floor space parameters at reserve matters, when that translates to the specific number of units to be provided, and ultimately the size and the tenure, etc., can be controlled at that stage adequately.
Okay, Mr. Wignall.
Yes, thank you, sir. Yeah, I agree with Mr. Mehta. The 77-23 split is our kind of standard go-to for when we do a tenure split with affordable units. But I think this, the size of the properties, etc., can be dealt with by reserve matters. I think it's a case of working out what's best on that affordable housing land and what scheme the best scheme that can be agreed, basically.
Okay, I'm happy to leave that to the reserve matters then. Thank you. Just turning through. Excuse me. There's nothing else in the main body. If we turn to the schedules. And I also had, can we also make sure we've got the drawings themselves, my comments on the drawings loaded up, please? Because that is schedule 1. So if we look at that now, well, they're loading it up. I can't see my comments on it now. Did the version that got sent to you have my PDF comments?
Apologies, sir. I don't know if it may well be my IT skills, sir, but I was looking a little bit baffled because I couldn't immediately see any comments. I did see a PDF document that was titled Section 106 Plans, Inspectors' Comments, sir, but I couldn't immediately see any comment bubbles or comments.
Yeah. So now I load up the one that went to you that isn't on there. Only the one on my own system is. So yeah, that's, I think, my fault. I've somehow accidentally given you the wrong one. Okay, so if I just take you through what my comments were now, then it was on so the public open space and landscape plan. In the key, it has a red dotted line around trees and hedgerows to be removed, but as far as I can see, there are no trees and hedgerows to be removed on the actual drawing itself. Is that correct?
Bear with me, sir. I'm just going to pull up a copy of the plan.
So just to make sure we're on the same drawing, it's 6658005C.
Apologies, sir. My system is on a little bit of a go slow at the moment in terms of opening up. I'm looking at Mr. Simons. If you could perhaps help me bring up the drawing while my system catches up.
Yes, I can certainly give it a go. So can you just give me the reference again to which drawing we're after?
Yes, so it's 6658 5C, and it's in schedule 1 of the 106.
Yes. Yeah, I'm there. me see if I forward it to Mr. Meta. Don't know whether if you have it on your email, Mr. Meta, I don't know whether that'll make it any easier.
No, I've now got them open.
Oh, good. I think it's PDF page 3 or 4 on the.
Yeah, certainly. So looking at the plan on my screen, and unless one of the appellant team corrects me, I think you're right, sir, that there doesn't appear to be any trees and hedgerows to be removed.
Is that your understanding, Mrs. James?
Yes.
Yes, I'm looking at it now.
Trees and hedgerows. Yes. I think that's right. I think that's right.
Yeah, I'm not aware that there were any to be removed.
Okay, so I think that key then is just that
Yeah.
just taken from a different.
Yeah, I think you're right. It's quite hard, isn't it, to sort of zoom into? But yeah, I think that's right. I think the key must have been taken from a different plan, but there isn't actually anything identified.
That's fine. I just wanted to clarify that. It's not an issue really. It's more just making sure that we were all on the same page. And then I had another question, which is, what are the grey lines with dots at the end of them that sort of go slightly outside the site and also alongside the hedgerow in the middle of the site? To the northeast boundaries, and also to the north of the hedgerow through the middle.
Yeah, I see. We might need to ask Mr. Crawford that question. And unless Mr. Meta knows, I don't know what those are. There's no key for them, is there?
No, agreed. So if Mr. Crawford,
can I go and ask that question to the team, and then we'll come back to you?
Yes, it might just be it's another layer of the drawing that should have been taken off before it was.
Could be.
I rather think it is the existing tree canopy, or that's just it's just like the grey sort of pencil line that where the canopy of the trees outside of the site boundary.
I'm sure Miss James is right. It'll be something like that, but I'll get the official answer from Mr. Crawford.
Okay, thank you. That was actually all I had as questions on that. So pending that response, and even if we don't get a response, I'm happy just to leave that as just one of those things on the drawing. It's not definitive. Okay. So schedule 2, I had no comments at part 1 or part 2 or part 3. We've discussed part 4. So for me now is what's left to discuss is the new information. And here I think I'll just turn over to yourselves to take me through it, please. Still, I haven't read it yet.
Yeah, I will. Mr. Meta. If Mr. Meta introduces it and it talks you through the mechanism, I can then perhaps, if it helps, just give a bit more flesh on the bones as to how we're saying it responds to what the CCG have asked. But I think the first thing is just to understand what it actually is, if you like, before we start talking about it. So I'll leave it to Mr. Meta to do that.
Okay.
Thank you, Mr. Simons. So, sir, the intention of these provisions were in a direct response to the letter that came in day before yesterday, on behalf of the CCG. And there's 3 components to the healthcare provisions. The first component is the definitions that we're proposing to slot into the section 106. The second component is the operative provision in terms of payment of the financial contribution. And then the third component, where I've offered 2 options, are the repayment obligations or equivalent that we can again slot into the section 106. So in terms of the healthcare contribution itself, using the letter that's been provided by Cambridgeshire and Peterborough Clinical Commissioning Group, and in their letter, I've come up with a formula that essentially based on the number of units and the occupancy rate that is contained in the letter, times by the floor space requirement and a financial contribution per floor space, we end up with the total contribution that's payable. And that should, hopefully if my maths is correct, but that should there or thereabouts get to the 1,032,585 figure that is within the letter from the group. In terms of the healthcare contribution definition, I've set out what that money is to be spent for or used for. And that's not only expansion, but provision of a future facility, but also increased staff, patient, resource capacity. Again, that wording is lifted from the letter that's been provided by the group. In terms of the contribution formula itself, I think there's two components or two issues just to raise at this stage. I have square bracketed the occupancy rate, and I believe Mr. Simons, and so you may have heard evidence during the course of the inquiry that as a result of the extra care scheme, there may actually be a less burden or certain alleviation in terms of healthcare facilities. So the occupancy rate is one way that the formula can be adjusted. So if you consider necessary through the blue pencil provisions to reflect the fact, as Mr. Simons will explain, that a certain population will be moving from the area to the extra care village, and as a consequence would not be increasing the burden on health facilities to that percentage. I've also added in a provision, sir, in the definition that gives you the opportunity to apply a discount to the total contribution that's payable, again, if through the evidence you decide that that is appropriate, because as a result of the extra care facility, there is a certain element of lesser burden on healthcare provision and facilities as arising from the development. The operative provision is the standard operative provision in terms of when the financial contribution will be paid. We've suggested triggers of 50% payable prior to 50% occupation of the units, and then the balance 50% prior to first occupation of 75%. But again, sir, that's something that we can discuss. And again, the blue pencil provisions and clause 4.2 will allow you to impose in your decision letter, if you wish, alternative triggers. The next stage of the operative provisions are just two carve-outs, essentially. One, that if there's a SIL funding bid or otherwise SIL contribution and SIL monies can be used for the provision of healthcare facilities, then there's no duplication between the Section 106 agreement and SIL. And secondly, in the event that it's agreed between the developer or between the owner, the council, in consultation with the group, that there could be on-site facility to meet the additional demand arising from the development, then again, there's an ability there to make sure there's no double counting between the Section 106 obligations and what's going to be provided on site. The third element is the standard repayment provision, sir, and I've provided two options for discussion. Option one follows option one follows the first appeal decision that you should have in your email, sir, which is the Stoke Golding appeal, and I've attached a copy of the Section 106 where that option was considered to be acceptable, or certainly the Section 106 was accepted by the inspector in that case and consent granted. And then option two, which is a slightly different mechanism, follows the Ledbury decision. And essentially it just depends on how the contribution is to be paid. And what I'm suggesting, sir, and what the provisions suggest, is that the financial contribution is essentially paid to the council. The council then has the obligation to pay that contribution to the group. And in those circumstances, I'd suggest option one in terms of the repayment provisions are most suitable, in the sense that the council covenants to pass the money to the group, but then has an obligation to request a statement of how those monies have been spent and ultimately try to recover any balance. So that's the broad mechanisms, which obviously very happy to discuss in further detail or address any queries yourself or other parties may have.
Before we sort of open it up, obviously, to you, sir, and to the floor more generally, just a couple of comments, if you like, on how we've sought to respond to. You've got, I hope, the sort of overview from Mr. Mehta of what the actual mechanism proposed is. Starting point is that we've shown evidence. You've got evidence of benefits to the NHS in general, and indeed to GP services in particular. In all the research that's before you, that's not been substantively challenged by Dr. Keith or by anyone else, or the research papers, etc. So there was this preliminary issue about necessity, and that's obviously something for you to take away and mull over and consider. However, that said, we have said from the start that it's the CCG who bears the role for strategic planning in this field, you know, in terms of allocation of funds and resources. And we've also said, we've been clear, we've been put in evidence that we've been trying to get a response out of them from the start. And to be fair, it sounds like Dr. Keith's been doing something pretty similar at her end as well. And, you know, we are where we are. So finally, the CCG has made, at the 11th hour, maybe, but they've still made it, a quantified request. And what we are essentially doing through this mechanism is offering to meet it in full, but obviously proportionate to how many units end up coming forward. They've assumed in the way they've done it that there'll be the full number of units. If it's lower, then obviously that should be proportionate to that. But anyway, the formula meets their approach, and we're doing that to give you that option, subject to the blue pencil clause, obviously all the rest of it, in order to be reasonable and in order to, you know, to show that the offers to sort of meet the CCG were legitimate, and here they are. Now, it's the first thing to say is it's that sum of money, however much it is, because it'll depend on reserve matters, is a sum of money which, as the 106 defines it and as the CCG requests it, can be used for a broad array of purposes. It might be to accommodate, as they tell us, increased staff, patient and resource capacity, whatever that means, that's CCG language, or towards a future new facility, an extension of existing facility. It's obviously, you know, obviously not for us to say, it's not for you to say, it's not for Dr. Keith to say, although no doubt she'll be able to have a say in what that money goes into, but no doubt in the end it'll be a sort of negotiation between Dr. Keith and the CCG or whoever else gets involved. You know, it's not for today. But really, to cut a long story short, if you accept that there's the CCG's case on need, then here it is. You've got one of two mechanisms, both tried and tested, that you can choose. And in a way, that's the end of that issue at the inquiry. But it is just worth picking up the, I don't know whether you've got that letter from them, sir. And if not, would you mind just trying to pull it up? Yeah. Did you say you've got it open?
Yeah.
Thank you. Yeah. If you just pick up, so we've dealt with, if you like, the first sort of almost 2 pages of the letter, which could take us down to there's a sort of subheading, clinical needs arising from the proposed development, which is the final 2 paragraphs.
Okay. Yeah, I'm there.
Okay, so we've dealt, so all the things I've just said apply to everything up to that heading, where they set out their 132,585 figure, which, as we know, will be potentially lower depending on how many units actually come forward at reserve matters, blah 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 blah. And you've got the mechanism. That's all. That's that. If you like. Then the CCG set out another heading, which is clinical needs arising from the proposed development, and they say, if you see at the top of the third and final page, they express a sort of in principle support for Dr. Keith's case at this inquiry. They say that in the second sentence on the final 3rd page, they say that the principle of potential gaps in revenue funding, particularly in the event where alternative funding sources are being allocated or made available, is a credible and realistic concern. Now, fine, you know, okay, but note the language. This is an in principle area of concern. What they've not done is set it out as an actual evidenced quantified issue that's attached to a sum that they meet any Reg 1-2 tests. They then say that due to the outline nature of this development proposal, operator not yet identified, there are significant challenges, they tell us, for a definitive revenue amount to be set out at this stage. Now, again, you know, we've got to we've got to just be careful about what the development management process can actually achieve in a world like this. You know, we are living in the real world of Section 38(6), and that is the Planning Act. There's only so much we can do. It is the CCG. It's not us, and it's certainly not you, sir. With respect, it's not the council either, who's responsible for the strategic allocation of whatever funding there is, the pot of funding and resourcing and all the rest of it. They say right in that last sentence that it should be on the appellant to propose some mechanism that sets out some sort of sum of money that they say in this letter, this is from the CCG, cannot definitively be quantified at all. I mean, obviously, and so they are asking something. I'm sorry to say, so we would have done it if they'd given a sum on some evidence, but they're asking for something that's outside the scope of planning, because we can't just put in a, you know, I don't know what, some sort of equation or whatever that could produce some sort of sum of money to be determined in the future. Who knows what it'll be, because you would have no way of assessing whether or not such a sum, I mean, I actually have no idea what the equation would look like, but whatever it is, whether it would bear a reasonable and proportionate relationship to the scheme, you know, all the rest of it. How do you trigger it? How do you maintain it? So I get their in principle, if you like, concern. That's to use their word. That it's in principle and it's a concern. Of course, funding for GP surgeries in general is, of course, it is a credible concern. It's a realistic concern, and to that extent, there's nothing between us and Dr. Keith on the evidence. And I'm sure we really do take her concerns very seriously indeed. But the reason that we've dealt with, if you like, the first two pages of the CCG response, but not tried to magic up some figure for the final page, is because there's only so much that the planning process can do. That's all I wanted to say by way of introducing the response.
Dr. Keith, I'm going to turn to you in a moment. I'm just going to summarise where I think we stand now. So we have this document's been provided, which, as written, I'm being told, covers off the CCG letter up until this clinical needs bit at the end. The second thing that we've been talking about is I might disagree with the principle of there needing to be a contribution, or if it being this high, based on the evidence provided so far. And if I do, then the mechanism for adjusting that is the occupancy rate, because that affects the whole calculation. Just, you know, Dr. Keith, when they say blue pencil clause, essentially it's when I can, there'd be a clause in there which would allow me to decide which option was chosen in how I write my letter. That's what the blue pencil clause means. So if that is the conclusion I come to, and this is, it's an if, then do I not need to have a definitive alternative option that the appellant's putting forward that I would choose, rather than it being left open?
I'll let Mr. Netter. I think the short answer is no. In terms of the mechanism, sir, you mean in terms of either option one or option two?
No, not option one or option two.
Sorry.
In terms of, we discussed before, Mr. Netter discussed before, changing the occupancy rate to reflect.
Yes. You heard, sorry, I misunderstood. The evidence, you do have to do it on the basis of evidence. We can't just sort of, as you for word 1, 2, 2 purposes, magic something up. We've put in a 1.5 because I think that reflects Dr. Keith's evidence. You've heard evidence from Mr. Sedgwick that the right figure is closer to 1.3. And so if you're going to be changing the occupancy rate, if because you might just decide on the basis of the evidence you've heard from Dr. Keith that 1.5 is an appropriate figure. If you decide from Mr. Keith that 1.3 is an appropriate figure, then so be it. But I think those are probably your options, if you like, on that one, rather than, because I agree, you couldn't just sort of, probably go off and try and work it out for yourself.
Okay, so the options are 1.5 as written, and the alternative.
I mean, Mr. Sedgwick's evidence clearly said 1.3 to 1.5.
Yeah,
he didn't,
so these
he had a range, 1.3 to 1.5 in his written evidence.
So what is your position? What do you think I should have? I think I need two options here. The 1.5, which is essentially the CCG's position,
And Dr. Keith's, I think it's based on Dr. Keith's sort of evidence as well.
I think. Correct me if I'm wrong. But what is yours? What do you think that number should be?
What 1.3 on the basis of? I appreciate what Dr. Keith's saying, but my note of what Mr. Sedgwick said on the stand was that his view was that an appropriate proportion was 1.3. And as I say, you've got the, at least then you've got an evidential, whatever you decide, whether you go to 1.5 or 1.3, there's an evidential basis for it, and then you can reach your own view on the evidence you've heard.
Because I think I have three options here in my decision. It would be, I suppose option one is, I'm thinking this through aloud, that final part of the letter from the CCG means I think this can't be dealt with through the 106. I'm thinking aloud now.
Yeah, so the CCG letter, there are two different things. So this is why I wanted to, that when you say this can't be dealt with through the 106, there are two different things that the CCG raises. Do you see at the top of page 2 that it could be maybe formatted a bit more clearly?
I could probably highlight as well, maybe.
Yeah, I'm sure you can. Yeah. So there's capital cost method, capital cost at the top of page 2. You see, so that's the first chunk. And that's what we have addressed because the CCG has given us a basis on which to do it. And then the second chunk that we can't address through the planning process for reasons I've explained relate to this heading of clinical needs. Obviously, I'll let Dr. Keith say whatever she wants to say.
Yeah, I suppose I think the simplest way in my mind to highlight the two issues is there's a one-off payment which basically would substantially be used to increase the physical floor space in our surgery, probably give us an extra consultation room, because at the moment we are literally full to bursting.
Okay.
And that, I think, is what that 132,000 would directly be put towards. It's a one-off fee that would go towards building costs.
Okay.
And secondly, what they're trying to highlight, but I agree, I don't think it's been written particularly clearly, is funding towards an annual recurring ongoing fund, basically, to cover the costs of this extra GP per year, which is what I was trying to present in my evidence in piece, because that is what we're going to need, and we evidence that on the care we already give to elderly people. It's going to cost us about one full-time GP per year. So yes, I completely agree, and I am very thankful for the fact that the appellant seems to have met first issue, one-off cost of 132,000, which would go towards building costs. This is going to cost us one full-time GP wages per year ongoing forever for the duration of this being open. And I appreciate they've been a bit vague and basically just said kind of, agree in principle with what I've said, but not actually put any figures in there. But they have highlighted the concern that I had, was that, we didn't know who the operator was. And I was kind of toned down on that, saying that was irrelevant. But I know that they have highlighted it as relevant as well. So I can't have been that stupid to have highlighted it as relevant.
Can I just say, there was no suggestion for a moment, Dr. Keith, that you were being thick. I think the key is that because the point is that whoever the operator is, they can be tied into the obligations of the 106, I think is the point. Yeah. But just to say, just on what Dr. Keith just said, obviously she's got a very good understanding of these issues, but I did just want to be absolutely clear on what this money's for. I know Dr. Keith sort of assumed and understand.
I know it will go to the CCG completely.
No, just to be clear, I know that you assumed, and I can understand why, given that language of capital cost, that it was going to be spent on building works, and it might be. I mean, I've got no idea, but that's why I just wanted to highlight to the inspector the breadth of what this money can be used for, because it isn't just physical infrastructure. It also could be, if the CCG decides that they want to, or not want, need to, whatever, that it could be put into increasing staff resource capacity. And that, I don't know whether that means a new staff room physically, or it might mean new staff capacity in other ways, but there'd be nothing in the 106 that stops that happening. If the CCG decides we're going to put this into staff and not into buildings, whatever, that could happen. And that's obviously a discussion, Dr. Keith, for you and them, and that the inspector and that we won't be part of in due course.
No, and I do understand that. Thank you for the clarification. I think my concern about this, and where I don't think we're going to be able to meet agreement really, is that, you know, there needs to be some sort of recurring annual fund to match the increased demand, quite simply.
So I think that's, yeah, for me, that's the key.
That's
So there's a one-off payment up front for the CCG and BNP.
Yeah, which we basically agreed.
Yes.
Yeah.
And then the bit we're not agreed on is the recurring payment. And I think, although I want to reflect on this when we have a break, I think that's just something I have to make a decision on in my.
I think that's right. So in the end, I think we've pushed it as far as we possibly can with the CCG. It would have, had there been a payment to make, it would have been the CCG who's the relevant consultee for you, you know, on the to set out what that payment should be and why it meets the Reg 122 tests. Because for whatever reason they've not done that, albeit they've sort of acknowledged an in principle concern.
Yeah,
we are a bit we are stuck. And so I think what I'll be saying in closings later on today is that certainly one way or the other, what you've not got, I mean, for all the evidence that you do have, what you've not got is an evidenced request, if you like, from the relevant consultee for an appropriate by appropriate, I mean policy compliant, legally compliant sum for whatever that sum of money would be. So I appreciate Dr. Keith's sort of concern over it. I really do. But as I say, then we sort of just come into all right, well, what can the development management process actually do here? And to what extent can we really get enmeshed into the sort of strategic allocation discussions that have to happen between the medical practice and the CCG? But I'll stop talking there. But I think, as you say, sir, in the end, it'll just be something you've got to reach your own. You've heard all the evidence, reach your own sort of view on.
This has been helpful. It's clarified in my mind. So I think, yes, we have the one-off payment with the two options, the 1.5 or the 1.3 multiplier.
Yeah.
For me to make a decision on. And then the recurring payment. And again, that's for me to make a decision on. And that might just go to the heart of whether the appeals are allowed or not, if that was the decision I made. But
if you decide that there's evidence to suggest a recurring payment would be necessary, and that we can't, I mean, you know, we can't supply one because there's no evidence to. So in the end, you might decide that goes to the heart of the appeal, and then that's it. But I mean, in those circumstances, it's a very difficult situation, not just for us, but for applicants in general to find themselves in, because you know, obviously, if consultees like the CCG aren't prepared to engage on figures like this, not just, and I'm not talking about this appeal, but just in general, development management in East Cambridgeshire is going to be very, very hard, because you know, in the end, as I say, we are all bound by Reg 122 and the MPPF and all the rest of it, which Dr. Keith, so you know what I mean. It's the requirements that any money that is paid has to be proportionate. It's got to be necessary, and the idea of that is to stop, you know, brown envelopes being exchanged outside planning inquiries.
It's to stop me going off and buying a Ferrari. I completely understand.
Exactly. Yeah. No, so that it is a difficulty, but in the end, sir, I think we probably have taken it just about as far as we can.
No, okay, thank you. And then the only thing I want to make sure I do understand is this option 1 and option 2 in the healthcare provisions.
Yes, Mr. Metter's your man on those.
This is. I'll just read them again now. Just give me a moment to do that now, please. What's the difference between them again? Sorry, you have to remind me.
This is a Mr. Meta question. He's been up all night doing them. So what difference? I think you're on mute, Mr.
Meta. Thank you, sir. So the difference between the two options. So effectively, option 1 is allows for a mechanism for the monies to be repaid. Well, to talk through option 1, so it's probably the easiest. Option 1 is 2 parts. Firstly, both options concern repayment obligations. Option 1 is split into 2 parts. Essentially, the council covenanting to pay the healthcare contribution to the healthcare body as defined. And then secondly, an obligation on the council to request from the healthcare body confirmation that it will use the contribution for the right purposes, and ultimately repay that contribution if it hasn't been spent for the purposes for which it was paid within 5 years. We've got the proviso there at the bottom of excuse me, option 1, sir, that makes clear that the council won't be any other obligation to ensure that the healthcare contribution is applied for the purposes, because of course it's not within its control, and making clear that the council will be discharged from the obligation, providing that it's paid the healthcare contribution to the relevant body and ultimately received confirmation from the healthcare body that it would use those that monies for the purposes for which it was spent. So this is just to manage the situation where we're not going to have the healthcare body as a party to the Section 106 in the usual way, but managing the situation that ultimately the monies will be paid. There will be a covenant for the council to pay that money to the healthcare body to make sure that the body gets it. But then there is a, shall we say, diluted mechanism and obligation on the council just to seek confirmation that the monies will be used for the right purposes and will be repaid if they're not. The second option, so for the appellant, sir, we would prefer option 1. Option 2 is a slightly nuanced version of that, and applies, I think, more readily that if the financial contribution is going to rest with the council and be used by the council, which I don't think is the case here, but in the event that the contribution was going to be paid to the council, used by the council, then this is the standard repayment obligation that says that the council will use the monies for the purpose for which they were paid, and if they're not spent within the 5-year period, then ultimately they'll be repaid to the owner. But on the basis here, as I understand it, the financial contribution is going to be paid to the council to then pass on to the healthcare body, as it were. Option 1 is probably the most appropriate, subject to any comments.
So are you asking me to choose?
Well, there's 2 options on the table, sir, and just for discussion, really just to aid this roundtable discussion, given the late nature of the request. But we can include both options in the Section 106, and effectively, sir, you can choose between those 2 options, or alternatively, we can decide pursuant to this session whether it's option 1, option 2, depending on the comments of the other parties.
Mr. Wignall, do you have any comments on this?
Yes, thank you, sir. If I may, Ms. James, we wouldn't be spending this money, would we? The idea would be we pass this on to the, isn't it?
CCG.
To CCG, yeah. Is that correct, Ms. James? Yeah. In that case, I would agree with Mr. Metcher. I think option 1 works better. I think it gives us greater flexibility to ensure we can have an agreement that if the money isn't paid or isn't spent, sorry, it gets repaid to us, so we can pass it back to the payee. So I think I'd express a preference for option 1 at this stage.
Okay. Well, I think that's the decision made, isn't it? Option 1 should be included and strike out option 2.
Yeah,
we can take that away, sir.
And just for your reference, sir, option 1 reflects the Stoke Golding decision, an appeal in Section 106 that you'll have on the email circulated this morning, sir.
Okay, so then, as far as I understand it, then obviously we've had the other changes to politics that we've discussed, and then we've got these extra provisions to insert. We just keep option 1 and get rid of option 2. And then we need to have a explicit blue pencil clause of either 1.5 or 1.3 for the occupancy rate placed in there. And otherwise, I think that's it. And as we've discussed, if I take Dr. Keith's side on this argument, then that just goes to the heart of the appeal rather than being a 106 issue.
Yeah.
Okay. Thank you. I think that's covered everything we need to cover. Up next is closings. But I think as this is all so fresh, I think now's a good time for a break anyway. And perhaps we just take that break. We can all just, particularly on this healthcare provisions element, just make sure that we have actually covered everything we wanted to cover and leave that in the break.
So just to check, so is there anything you wanted to check? You wanted to just check on conditions? There was the crossover between the LEMP, wasn't there? I think, and the maintenance in the 106 that I think Mr. James wanted to come back to.
Oh yes.
But by that I mean the interaction between conditions and the 106, or have we covered it all?
So condition 28 we've covered, which is a description of extra care.
Yeah.
James, what other ones were? So you're going to have to remind me.
Yeah, I should have checked first.
I think one was the SUDS maintenance.
Yes.
And the other was the LEMP that needs to be a bit tidied up.
So condition 5, no, not 5.
20 is the SUDS one, I think.
Okay.
I haven't got the LEMP. I think that was one of the first ones, wasn't it?
LEMP is condition 6. Yeah.
So yes, condition 20 SUDS. So are you suggesting, Mr. James, that we need to add a clause into the 106?
I think so. I think Russell and I were chatting about something similar to the public open space category in the 106. Obviously, we'll leave it to you, but sometimes it might be easier to have something within the 106 that.
This is for SUDS, isn't it, that we're talking at the moment?
Yeah, well,
so.
Oh, sorry.
Condition. Is that right? Sorry, that's the one we're talking about. Condition 20. Is that?
We were. I thought we were on 6 then, but no.
Oh, sorry.
No.
Inspector,
no.
which one do you want to touch
I was on
first?
condition 20. Let's
Okay.
Now.
So yeah, so 20 is the requirement to put in a sort of SUDS maintenance arrangements, and then to build out in accordance with details and maintain in full thereafter. And yeah, I mean, I wouldn't mind Mr. Meta giving his view, but I don't think we discussed it earlier on. I myself, I don't see the requirement for an extra 106 obligation. Mr. Meta might, but just because, as I say, this condition's pretty straightforward, really. I mean, we don't need, through the auspices of this permission, to get into, paying money to maintain or whatever, because if the maintenance doesn't happen, then it's a breach of, as I said at the condition session, it's an enforcement matter, isn't it? A breach of condition matter. But yeah, I mean, Mr. Meta, do you have you might not have looked at condition 20, but it's the one. There's a requirement to submit, get approved, and then implement, and then maintain thereafter a long-term maintenance arrangements for drainage.
Yeah, thank you, Mr. Simons. I've just read condition, and I think it depends on the position that we take with the LEMP, sir, as well. I think, as Mr. Simons has said, I entirely agree. I think condition is appropriate for both of these elements. Having said that, with SUDS, this is an outline scheme, so if it is likely that SUDS are going to form part and parcel of the open space, then I personally feel quite comfortable including provisions in the section 106 that essentially will replicate the open space provisions. We agree a scheme. There is a requirement to provide the SUDS by a particular trigger point as agreed in that scheme, and then an obligation in the section 106 to maintain that SUDS infrastructure until such time as it's transferred to a management company or another management body. And assuming, sir, if we do take a similar view for the LEMP, then Mr. Wignall had a conversation about the LEMP, and I had a conversation about the LEMP yesterday, and agreed that we could very easily transpose those obligations into the section 106 in exactly the same way as we've done with the open space, albeit references to open space will now refer to SUDS and or LEMP.
Well, in that case, maybe having said all the things I said.
Yeah.
Sorry, so I interrupted you.
I mean, there's almost certainly going to be SUDS in the open space, isn't there? That's just how these things work on this size of site. So it does seem to make sense. And if the appellant's lawyer is saying that that's okay, I see no harm, certainly, in adding that in. And as you say, just a change to the public open space clause. Let me just turn to the length as well, though. Yes, but this is what I wanted, isn't it? To incorporate this into the 106 instead of the condition. And Mr. Mehta, do you think, and Mr. Wignall, do you think this is fairly easy for you to take away and incorporate in terms of the actual detail of the wording?
I think, certainly from my perspective, I think it's a copy and paste exercise with the open space provisions, replacing open space with LEMP and or SUDS. So I don't think it's an onerous exercise subject to any views from Mr. Wignall.
No, sir, I'd agree with Mr. Mehta. I don't think it's a particularly onerous task, just a bit of copy and pasting to do.
And then obviously I'd make appropriate changes to the conditions to reflect to condition 6 to reflect that. Mr. Simon, is there anything else you'd like to say? Okay, in that case, then I think, yes, I think I'm happy to agree that those should be added to the 106. Yes, Mr. Mehta.
Oh, you're on mute, Dave.
No, thank you. I should be quicker at this by now. I was just going to suggest, sir, that just looking at the wording of condition 6 and 20, subject to any views of Mr. Simons and Mr. Wignall, that it may well be that those conditions can be completely dealt with in the section 106. If we're agreeing a scheme in the section 106, we'll be agreeing a trigger for delivery of those elements, and equally in the section 106, we'll be dealing with the maintenance and management regime in the same way as open space. You may find, sir, I think it's probably right to say that condition 6 and 20 can be removed and won't need to be duplicated.
Yeah, I think that's right.
That raises issues, though. So, for example, biodiversity net gain was still the percentage of that we were still discussing, weren't we?
Yes.
I think it was left that I would make the decision in my decision letter.
On the percentage of BNG,
yeah.
You mean?
Yeah.
And whether, I thought, was that not one where there was, you asked for policy basis, and I'm not sure you were ever given one.
Yeah. So
I thought Miss James might have taken it. I thought, was this one? I might be misremembering where Miss James was going to just have a proper look through and check, see if there was a reference.
Yeah, I've emailed it to you this morning.
Oh, sorry.
No, that's okay.
Let me read that then.
It's just I'm just referring you to the natural environment SPD, which refers to a significant gain but doesn't provide a figure. And then I've just referred you to NE6 with that document.
So I think then we probably are in territory where we've not got a specific bit of policy support for a quantified percentage of BNG.
I think I prefer to give myself a bit of wiggle room in terms of time to digest all that, which means keeping that as a condition, because then I can. That's fine. Then I can make that decision as part of the decision rather than in the 106. Obviously, I can't because it's a finished document that just lands on my desk. So, is it possible for the wording of the 106 to be vague enough that it just accepts whatever decisions I make on the wording of the condition?
I need to stop raising and lowering my hand. That's exactly the point I was going to make, sir. The blue pencil provision in the 106 at paragraph 4.2 would allow you in your decision letter the flexibility to impose a different percentage for BNG. But what we could also do, subject to Mr. Wignall's views, is in the definition of the length in the section 106, we could say, including a scheme for 10% biodiversity net gain, into brackets, unless the inspector decides in his decision letter that a different or alternative percentage is necessary to make the development acceptable, or something along those lines. And I think that would, in addition to the standard blue pencil provision, give you specific latitude in your decision letter, sir, to cover that off. But equally, I don't feel strongly either way as to whether or not it's conditional section 106. That it may be neater to shift everything into the section 106 in the same way as open space, but I'm happy to be guided by you, sir.
It's not unusual to have conditions 6 and 20 and then have the maintenance element of it only in the 106. So I'm happy to keep it like that if that's okay with you.
Okay, I'm content with that, sir. So just to be clear, the section 106 will only deal with the maintenance and management aspects, leaving the conditions to do the heavy lifting in terms of agreement of the scheme and
yes.
Trigger for delivery.
Yes.
Yeah, thank you, sir.
And Mr. Wignall, is that okay with the council?
Yes, sir, that's fine, thank you.
Okay. Is there anything else we need to discuss on the 106? Okay, thank you. In that case, unless there's anything else that anyone wants to raise, we will have a break and then come back with closings. And as I say, subject to perhaps just all of us reflecting on everything we've had to take in quite quickly on the CCG, and I'll open that up for discussion when we resume in case anyone wants to raise anything else.
I'll just make it just on closings. I've just received very helpfully, thank you for them, Mr. Smythe's closings myself, so thank you for that. I just wanted to check with Dr. Keith, was whether or not she was intending on doing one. I think she probably is intending on doing one. Whether or not she'd reduced anything to writing, and if so, I just wanted just a request from me whether or not it could be pinged around in writing if at all possible.
I'll send that round. I just wanted to wait for the CCG discussion.
Of course,
add a paragraph
of course. No.
That, which I've now done.
Of course.
Thank you.
Thank you very much.
Just so I think we can all reflect this, and because we're not particularly pressed for time, let's just maybe have a half-hour break now, just give us time to actually make sure we are comfortable with the CCG, and then we can come back and by then, of course, I think everyone would have had a chance to properly digest it.
Yes, sir.
Okay, in that case, we will adjourn now and resume at 11:30.
Thank you.
Okay, thank you. The inquiry is adjourned. Thank you. Hello, everybody. The time is 11:30 and the inquiry is resumed. Okay, so I was obviously asking everyone to reflect on what we discussed, in particular the CCG elements. Does anybody have anything that they'd like to raise first, what we've already discussed?
I received an email just during the break, which I forwarded to everyone. It was just about changing one word, I think.
Yeah, I will. Yeah, no, it's from. Thank you for that, Dr. Keith. It was from. You might not have it yet, sir, but it has been sent to Alison Bell. It's an email from someone called Ricky Ching, who is the Senior Associate Town Planner at NHS Property Services. So it's actually from, as it were, sort of from the NHS. He's obviously been watching along, and he has suggested there was a clause about back on this healthcare contribution. 1.1.5 of it says, if the owner hasn't yet paid the healthcare contribution or part of it in respect to the infrastructure towards which the levy under the SIL regs could be applied, then the obligation shall cease and determine absolutely. So the point is there's a clause in there that says if it ends up being covered by SIL, or if it could end up being covered by SIL, then we won't have to pay under the 106. He has said, Mr. Ching has said that this is in case the council decides not to grant SIL funding after reviewing the application on the project, but they could have granted SIL. I suggest this is cleared up, and he says instead of SIL could be applied, he says it should be along the lines that it would be applied. So he's essentially making it the if you like, the carve out from the need to pay the 106 would only kick in circumstances not where SIL could be applied, but where SIL would be applied. And just to say we're content with that tweak, if you like, to cut a long story short, and then the final obligation that you get in a couple of weeks' time, it will reflect this suggested amendment from Mr. Ching. I should also say that he says in the same email, just on the other half of the conundrum that we were talking about, he says the request on the revenue side, based on Tamara's evidence and the need to meet Regulation 122, is unfortunately not a position we'll be able to progress at this stage of the inquiry. That's what he says about that, for what it's worth. But yeah, hopefully you'll get that email from Dr. Keith, forwarded from Dr. Keith, coming through soon.
Okay, thank you.
If I just may, sir, sorry. On that point that Mr. Simons raises, there's also another could in 1.14. So would we change all coulds to woulds? Yeah, thank you very much. Yeah, thank you.
Okay, well, if that's agreed between the parties, then I'm happy to go with that. Thank you. One other question I had, I'm not sure if we agreed before what the deadline would be for the final engrossed 106 to come through.
No, I was I don't think we did. I was going to suggest 14 days as a from today's date. Let me see, which would take us to close of play on Friday, the 18th of February. If that's acceptable to you, Inspector.
Yes, that's fine.
Thank you.
Okay. Thank you. Okay, so that's everything from me. Is there anything that anyone else wants to raise before we move to closings? Okay, thank you. In that case, I will turn over to Mr. Smythe. You're on mute.
Sorry, sir. Have you got a copy of it?
Yes, thank you.
Fine, great. Fine. So at the outset, it's helpful to record the large measure of agreement between the parties. It's common ground that the council can demonstrate a 5-year supply. The development plan is up to date and the proposal should be judged in accordance with it. That Growth 2, which sets out the locational strategy for the district, should be afforded full weight. The proposal represents inappropriate development in the green belt, such that the onus lies on the appellant to demonstrate very special circumstances, and there is a need for the form of development proposed. So in respect to the landscape objection, the council remains of the view that the appeal would give rise to significant harm to the character and appearance of the area, and that the proposed mitigation will have little effect in tempering the interruption to long-distant views, particularly given the height of some of the buildings. So doubtless, sir, you've taken a careful note of what was said at the round table, so it's not repeated here. You're invited to prefer the evidence of Mr. Brown and find that the proposal offends ENV 1 and 2, and therefore HOU 6. So turning next to the alternative sites assessment. The application was submitted to the council in February 2020. The assessment was provided for the very first time when Mr. Belcher's proof was served 22 months later. No alternative sites evidence was provided at application stage whatsoever, notwithstanding that the council indicated that it was required, as was recorded by the appellant's own planning statement. Mrs. James's oral evidence was that she attended a Zoom meeting pre-refusal with representatives of the appellant, where she indicated that it would make the appellant's case stronger if the assessment was provided. A more sensible approach would be to undertake the survey, which can inform the selection of the appeal site. The appellant has done the opposite. It has put the cart before the horse by providing the assessment after the local authority had refused the application. It is an after the event justification for the appellant's choice. In cross-examination, Mr. Snedden confirmed that he did not know how the appellant came to select the site for the proposed development and was unaware whether any informal site selection assessment was undertaken. It's common ground following cross-examination of Mr. Belcher that in the majority of cases with which he has worked, the assessment has been submitted at application stage. As the assessment was submitted for the appeal, it did not inform the site selection or the proposal. The appellant did not make contact with the council to try to agree the methodology or broad parameters of the approach to be undertaken, or obtain the knowledge of officers who may have information which cannot be gleaned from a desktop study. If the filter deployed is too fine and discriminating, there's a danger that sites will be missed. If the filter is wrong or too constrained, this could cast doubt on the conclusion, as the assessment would underestimate the number of potential sites. So for you to have confidence that the assessment is robust and reliable, it's important that the methodology is transparent. Penultimately, the appeal site would fail to meet the assessment size filter, such that it would have been excluded because it's 8.4 hectares, and so you know the filter ends at 7.5. Similar proposals have been granted planning permission which are considerably smaller than the filter deployed here, and would therefore have been excluded from the search had they fallen within the geographical scope. The council has not advanced a positive case identifying specific sites which are suitable and available, but it's the appellant's case that it has undertaken a thorough and comprehensive assessment of both the district and the wider market area, which demonstrate that there is no other place to locate the appeal. As was remarked in opening, that's a bold assertion, given that the green belt only covers 3% of the district. Having scrutinised the evidence, the council remains doubtful that the assessment is as thorough and as comprehensive as the appellant suggests. Within an hour of the council's conference with me on the 19th of January, Mrs. James sent an email seeking clarification from the appellant about the methodology used and querying sites in Ely and Soham. No response to this request was received. And so, as I said in opening, that was unhelpful. So you cannot have confidence in the reliability of the assessment. It's for the appellant to satisfy the inquiry that the methodology used is appropriate and cogent. Central to that are the filters deployed. It's admitted the filters deployed are unrealistically narrow and discriminating. So first, sir, the size filter we say is not justified. Firstly, there's no evidence to justify such a narrow filter, save for a generic assertion that, quote unquote, care village operators and developers typically require at least 3.5 hectares. And Mr. Belcher has rejected out of hands any sites which are more than 7.5 hectares without considering whether the development can come forward there on part of the site. This is artificial. This is important as there are a number of sites in excess of 7.5 hectares, such as at Soham, which should have been considered but were excluded. So the 3-year time horizon filter is not justified. There is no cogent basis for adopting such a narrow window. A more conventional time horizon is 5 years. As was put in cross-examination, the appellant has adopted a high-risk strategy. Its evidence is confined to sites which are capable of being occupied within 3 years. In these circumstances, sir, if you were to consider that the better time frame was 5 years, the appellant's evidence does not help you at all. We simply don't know how many sites fall outside the appellant's time frame, how many sites would be deliverable in 3.5 years, or 4 years, or 5 years. The appellant's assessment does not help us at all. So if you are not satisfied with one or both of the filters, it follows that the assessment cannot be relied upon. But it gets worse. The assessment excludes the site east of Clare House Stables solely on the basis that it's too small. Mr. Belcher agreed that the assessment significantly underestimates the size of the site, as it is in fact 5.67 hectares. It lies outside the Greenbelt and has outline planning permission, which I then recite there, sir. Mr. Belcher, for the first time in his oral evidence, said that it would have been excluded on the basis of its shape. That was not a point mentioned in the assessment. It was not put to Mrs. James in cross-examination. So when you intervened and asked how confident Mr. Belcher was that there were not other inaccuracies in the assessment, he replied that, and I quote, he hoped not. He did not assure the inquiry that since the discrepancy was identified in the council's opening on the morning of day one, that he had spent the next 72 hours before giving evidence going through the assessment with a fine-tooth comb to check that it was accurate, and that this was in fact an isolated or rogue error. In these circumstances, the inquiry cannot be confident that the rest of the assessment is free of errors. And so I make clear, sir, the council does not have the time or the expertise to scrutinise the whole of the assessment in detail. And Mrs. James never claimed that she did. And so I only say that, sir, if the submission comes from learned friends saying, well, if there are other errors, the council would have picked up on them. But that's not the task the council has undertaken. The requirement on the appellant to be entirely transparent and objective about the assessment is all the more important given that everyone knows that it is the only one calling expert alternative sites evidence. The assessment would command more confidence had the appellant reached out to the council to try and agree the parameters of the search. Had it done so, the assessment could have been common ground, as was the position in respect of the harm to heritage assets, where the council accepted the appellant's heritage assessment in full. So I say, sir, that you cannot rely on the assessment. Mr. Belcher's concession in cross-examination that the appeal site would have been excluded as it fails to meet the assessment size filter strikingly reveals the shortcomings of the assessment. So you cannot be satisfied that the proposed development is unlikely to be accommodated within the built-up area and outside the Greenbelt. With so little Greenbelt in this district, such a proposition accords with common sense. For the appellant to demonstrate there is unlikely to be anywhere suitable and available in the 97% of the district outside the Greenbelt is a tall order. In the alternative, sir, if you are prepared to afford some weight to the assessment, the methodological shortcomings temper the weight which can be afforded to it. So I turn next to HOU 6. This is the development plan's policy on residential care accommodation. The appellant interprets the type of development to which it relates narrowly. That is not how the policy should be read. It's clear from the explanatory text that the expression residential care home has a broad meaning, which includes retirement homes and villages and extra care housing. The appellant's approach flies in the face of the explanatory text, which accompanies the policy. The council must be right when it submits that the appeal ought to be judged by HOU 6. Indeed, that was the appellant's view at application stage. It was the first time in Mr. Warner's proof that the appellant advanced the contention that HOU 6 did not apply. Does the appeal comply with HOU 6? It's common ground, sir, that the first bullet point is satisfied. So in these circumstances, whether the two other bullet points are met turns on firstly whether what the inquiry makes of the council's landscape objection, and secondly, sir, whether you accept the assessment. If the appellant does not win on both these points, then it follows the policy is offended. So I deal next with Grove 2. Given the site's location in the Greenbelt, there's a danger of losing focus on the fact that it's common ground that the appeal offends policy Grove 2, which should be given full weight. Directing the locational strategy of an area is the number one thing that any development plan does. It is a very, very important objective of any development plan. Mr. Snedden agreed in cross-examination that Grove 2 was not some incidental policy. It is one of the most important policies of the development plan. There are 47 main policies, together with the housing and allocation policies. Grove 2, in the council's view, stands at the top of the tree. Setting settlement boundaries is an important component to Grove 2. The policy seeks to jealously protect the countryside of this rural district out with the settlement boundaries which do not fulfil the exceptions. That is how the council, reflecting the wishes of local people, has chosen to plan for the district. This is an expression of the government's imperative that the planning system should be genuinely plan-led. In arriving at this, the council was adopting a very important planning judgment. In doing so, it has the full support of national policy. And so I conclude by saying, sir, that conflict with Grove 2 is a big deal. So the next issue, sir, can the appellant discharge its burden of demonstrating very special circumstances? Sir, I recite national policy, which I shan't repeat now. At paragraph 19, sir, I then identify areas of common ground following Mr. Snedden's cross-examination. It's agreed that the Greenbelt Review affirmed Bottisham's location within the Greenbelt. Secondly, it forms no part of the appellant's case that the site does not perform any of the functions expected of Greenbelt. And thirdly, it makes no difference which or how many of the purposes of the Greenbelt would be harmed. The inquiry, sir, has the benefit of a recent inspector's decision which considered the impact of residential development in very close proximity. So I should perhaps delete the word close in light of your previous observations. In very close proximity to the appeal site on the openness of the green belt. Inspector Woodward found that 4 dwellings gave rise to an unacceptable impact. If that conclusion was reached there, it must apply with even more force for this appeal, as it is far larger and more impactful. Whilst there are significant benefits of the appeal, which properly weigh in the appellant's favour, these do not clearly outweigh the harms identified. So irrespective of the landscape harm, plainly the appeal will significantly detract from the openness of the site. So you are invited to find that the appeal offends NV 12. The appellant's contention that this policy is inconsistent with the framework to some small degree because it does not explicitly refer to the very special circumstances test is unconvincing. ENV 10 and the accompanying explanatory text explicitly refer to the framework. If the appellant is correct, it would mean that the examining inspector, post-publication of the framework, approved the council's local plan, which contained a greenbelt policy, which was inconsistent with national policy. Sir, to quote the legal maxim, to state the proposition is to reveal its absurdity. So I turn next, sir, to heritage assets. That this is an issue of common ground should not obscure its importance in the final planning balance. The appellant's heritage assessment finds that the appeal will have a harmful impact on the setting of the listed Bottisham house. It's common ground that the extent of the harm is limited and constitutes less than substantial harm. In these circumstances, the Section 66 statutory duty is engaged. Further, the appellant's assessment finds the appeal will have a harmful impact on the conservation area. Again, it's common ground that the extent of the harm is limited and constitutes less than substantial harm. So, sir, how should you treat the issue? And so I then quote from various cases which I suspect will be known to you, and I shan't read them out here. Turning to paragraph 26, the agreed harm to the heritage assets is not a showstopper. It does not provide a freestanding reason to dismiss the appeal, but ought to be added to the negative side of the ledger in the final planning balance. The presence of this consideration weighs against the appeal materially, but not significantly, so as to make it all the more difficult for the appellant to demonstrate very special circumstances, which clearly outweighs the harm. So I turn to the development plan. It's common ground the development plan is up to date and the proposal should be judged in accordance with it. From the council's perspective, there are a number of roads which lead to the destination that the appeal offends the development plan as a whole. So, for example, sir, let's assume that the appellant wins the landscape battle. So if you prefer Mr. Crawford's evidence and find that the appeal does not give rise to an unacceptable impact, it follows the appeal would comply with ENV 1 and ENV 2. In these circumstances, it's a council's case that the appeal is not in accordance with the development plan, as it still offends Grove 2, HOU 6 and ENV 10. I then quote, sir, from national policy, and the inference I draw from that, sir, is at paragraph 30. This is the clear indication on the part of government that approving development contrary to an up-to-date development plan is the exception rather than to be regarded as commonplace. One should not grant planning permission for development which offends an up-to-date development plan lightly. This is particularly the case when Mr. Snedden agreed in cross-examination that The locational strategy of growth 2 is a very important part of the development plan. The onus rests on the appellant's shoulders to satisfy you that you ought to depart from the usual position. Now, so it's not the council's case that the framework, paragraph 12, displaces or overrides the statutory test, but it clearly gives a steer as to how one should approach the planning balance in circumstances where a proposal is contrary to an up-to-date development plan. It's common ground that there are a number of significant benefits which weigh in the appellant's favour, but it's submitted that they are not so potent as to outweigh the conflict with the development plan. And so I penultimately, sir, deal with the point as to whether the site is in the wrong end of the district. In addition to the council's case that the appeal offends important elements of the development plan, it remains troubled that in the real world, the site chosen by the appellant is at the wrong end of the district. Unlike more sustainable settlements such as Ely, Soham and Littleport, Bottisham possesses no train station. It has a limited bus service with no service at all on Sundays. Unlike the other settlements, it has no dentist. The site is detached from the growth areas of the northern part of the district, and it lies at the quote-unquote younger end of the district, close to Cambridge. So, sir, in conclusion, the council says that the proposal does not represent sustainable development. The site is intrinsically unsuitable, given that it lies in the open countryside, contrary to growth 2, within a tiny part of the district protected as greenbelt, and also within the setting of the conservation area and listed building, which gives rise to less than substantial harm to those assets. It offends the development plan. For reasons which are still unexplained, the appellant has chosen a site in one of only 3 villages in the district, which lies within the greenbelt. The council finds itself in a stronger position to resist the appeal than it was when the planning application was first submitted, as at that time, the council possessed a housing land supply shortfall, which is no longer the position now. So the council says that very special circumstances have not been demonstrated, which clearly outweigh the harms identified. And so in those circumstances, the council asks you to dismiss the appeal.
Thank you, Mr. Smythe. Thank you very much. Okay, next it's Dr. Keith. Can I just ask, have you emailed through your closings in writing?
I have, yes.
Okay, I haven't received them yet, but that's fine.
I have, sir, just so you know.
Okay, thank you. Oh, wait, so I've done something weird with my Zoom. Okay, I fixed it. Okay, I somehow minimized it. I don't quite know how. Okay, so please proceed in your own time, Dr. Keith.
Thank you very much. So as you all know now, but I'm just going to introduce myself in case there's any new people watching on the YouTube link. My name is Dr. Tamara Keith, and I'm a partner of Bottisham Medical Practice, and I'm representing the views of all the partners of Bottisham Medical Practice. Bottisham Medical Practice strongly oppose the proposed development on the basis that it will overwhelm the primary care service provided by the medical practice. The location is not sustainable, and the location is not appropriate for this development. The gross similarity of the development for care home in terms of GP requirements means that this is what the GP surgery must prepare for. Mr. Sedgwick and Miss Venables accepted that this development is for the elderly, only available for those 65 and over, with an average age of 75 to 80 years, and has on-site 24-hour care available. That no resident would be evicted due to worsening care needs. It has also been agreed that this development is open to those with NHS continuing healthcare needs. In my main evidence, I described in detail 3 case examples to illustrate the exceedingly high care needs these patients have, and thus their demand on a GP surgery. It has been accepted by both Mr. Sedgwick and Miss Venables that no resident would be asked to leave if they were terminally ill and required palliative care. There are ample elderly care beds available in Bottisham. There are 4 elderly care units currently in Bottisham Village. They currently have 1 in 4 beds vacant. This demonstrates significant and ample elderly care accommodation in the local area. There is a high elderly population in Bottisham. We already have a very large proportion of elderly residents in the catchment of Bottisham Medical Practice. 13.3% of our patients are 75 and over, and this development would increase this figure to 17%. I have presented figures in my evidence in chief and draw the attention of the inspector particularly to Table 6 and Table 9 in core document 11.1. These figures demonstrate that firstly our practice is the smallest in the area, but also that we have by far the highest proportion of elderly residents, and that is before the influx of an additional 255 elderly residents. The population of Bottisham is 2,100 people, and the surgery catchment is 5,902. The market catchment area contains 30,002 residents. Miss Venables confirmed in cross-examination and in her evidence in chief that the market catchment area for this development is 30,002 people in a 10-mile radius. Surgery radius is 3 to 4 miles, and we have a population catchment of 5,902. This proves, therefore, that in fact the vast majority of residents will come from outside our practice boundary. These will thus be new residents to the area, even though the appellant has tried to claim that these will be local residents not adding to our village or practice population. Miss Venables confirmed 39% are predicted to come from within a 3-mile radius. This means 61% will come from outside our catchment area. This demonstrates further my concern that this is an influx of new residents, new elderly people with care needs, new elderly people who may have high care needs requiring significant input from the GP. New elderly people who are welcomed and encouraged to the development with the phrase, if care requirements change, their home will not. This is an accommodation facility for the elderly to stay until you die. This is an accommodation unit that will require significant input from the GP, for all residents may have palliative care needs. I reiterate some of my main points. This retirement village has to be treated in the same way as a care home from a GP perspective. But why, I hear you ask? We have heard that all residents will be over 65, the average age being 80 years. We have heard that all residents have access to 24-hour care, and we've heard that no resident will be evicted due to increasing care needs, and we will all have access to palliative care at the time their life is coming to an end, as after all, in the opening statement, Mr. Simmons said, if care requirements change, their home will not. After all, they own their housing unit. Of course, they cannot be evicted. We've heard about aims to have a third of low-level needs patients, a third with medium-level needs, and a third with high-level care needs. But it's been confirmed during cross-examination of the appellant witness, Mr. Sedgwick, that there is absolutely no way to control or limit these levels. It is just that, a blind ambition with no guarantee at all. There is no method to control the numbers of high care needs residents in this development. I reiterate, no one can be asked to leave due to advanced care needs. They own the accommodation unit. Therefore, as a GP, I must plan for 255 residents with high level care needs, as this is what planning permission, if granted, would permit. With regards to GP workload, the appellant has helpfully reminded me that we have a low patient to GP ratio. This does not demonstrate spare capacity, but further illustrates my evidence that our current patient demographic is high demand, requiring more GP time per patient than the average surgery demographic. We've heard suggestions that patients could move to Bottisham and remain with the previously registered GP without the understanding from the appellant witness that this is simply not possible. The current GP would have to be agreeable to offer home visits for the elderly resident outside their catchment area. This would be exceedingly unusual. We do not offer this to any of our 5,902 patients, and I am not aware of any current elderly patient in our catchment area registered elsewhere. All of our current 229 care home residents are registered at Bottisham Medical Practice. It cannot be assumed at all that any of these 255 residents would be registered with any GP other than Bottisham Medical Practice. With regards to funding, the increased demand will not be met by mapped increased funding via the GMS contract, which means that existing services will be cut and the proposed new development residents would be dangerously underserved and the safety of current patients compromised. Bottisham Medical Practice have highlighted in core document 11.1, paragraph 68, an annual shortfall in funding received by the GMS contract and the costs that this will incur from providing healthcare for the residents of this development. We've calculated an income via GMS of around £29,000, but costs of around £100,000 to pay for the additional GP doctor time. The CCG have confirmed these figures are credible and realistic in their CCG letter dated the 2nd of February 2022. This will be an ongoing annual and recurring cost to the Bottisham Medical Practice. It is possible that the addition of another elderly care facility within Bottisham would result in the closure of our list to new patients as a way of protecting the safety of our current patients, and potentially the closure of the practice as a whole, as it would be unable to retain staff and no longer be viable. The CCG letter dated the 2nd of February has set out capital cost contributions, which we have discussed in the 106 agreement today. The CCG also confirmed that the Office of National Statistics data identified a significant increase of people with long-term health conditions in the age profile of residents from this development. The CCG confirmed these incoming residents would require more support from local healthcare infrastructure and place an increased burden on existing services. It is not just me who has this view. The CCG also agree. The CCG confirm that my concerns about gaps in revenue funding are credible and realistic. They also confirm my concern that as when we were drawing up evidence, we were unable and unaware to know who the operator would be, and that it is significantly challenging for a definitive revenue amount to be set at this stage. We now know the appellant did know who the operator would be, but withheld this information until the minute before my evidence in chief. So neither Bottisham Medical Practice nor the CCG could use this information to assist in any calculations of ongoing annual payment for healthcare services. The CCG say the onus should be on the appellant to propose a mechanism that will address these matters, the matter of funding shortfall on healthcare in the area. The CCG states if unmitigated, the proposal could be considered unsustainable development. I have not seen any evidence from the appellant for any meaningful funding towards primary care to facilitate us in providing the healthcare services this development will demand from us. We have received no reassurance from the appellant that increased funding would be forthcoming to prevent deterioration of the GP service currently offered to protect our current patients. I must plan for what the Planning Commission will permit, not what the multi-million-pound developer operation says they aim for. Aims are just that, not guarantees, colourful ambitions and illustrations to stretch the truth and manipulate reality to influence our decision makers. This Planning Commission, if granted, would permit 255 residents to live in accommodation designed for the elderly with on-site 24-hour care. No resident will be evicted due to increasing care needs, and in fact, no resident is prevented from purchasing a unit due to having advanced care needs. The accommodation will be open to those who qualify for continuing healthcare, the very highest need patients in our community. These facts have been accepted by the appellant witnesses. These facts do not cease to exist if they are ignored in the planning process. The main difference from a registered care home is the fact the carers are CQC registered and not the retirement village as a whole, because the resident has leasehold ownership of the accommodation unit in which they reside. The other difference being the layout of the accommodation and leisure facilities. In all other ways, and importantly for a GP, the age demographic, being the average age of 80 years, and open to residents requiring care, whether low, medium or high level needs, thus demanding healthcare services from the GP, is the same as a registered care home. Current 1 in 4 elderly care accommodation bed vacancy in Bottisham demonstrates there is no need for accommodation of this type from local residents. A need for extra care accommodation in East Cambridgeshire district may have been demonstrated, but is not for the small rural village of Bottisham to take the burden of this need when there are 1 in 4 elderly care beds vacant in our village. Why should the very first retirement village in East Cambridgeshire be built in a village where there are already excess elderly care accommodation and not in an area with low-level elderly care, which would thus be more able to meet the GP care demands this development will create, and have a greater local requirement for elderly care accommodation? Bottisham is a rural, small village. We already have the largest proportion of elderly residents compared to all other GP surgery catchment areas in this region. This development would add 255 elderly residents to a population of Bottisham village of only 2,100, and our surgery population of 5,902. The population of the area is already grossly skewed towards the elderly, more so than any other GP catchment area in our region. We have received no reassurances from the appellant that increased funding would be forthcoming to prevent deterioration of the GP service currently offered to protect our current patients on a recurring annual basis. We are genuinely and seriously concerned of the impact this development will have on our current patients, the workload of the GP team, and thus our ability to retain staff, and therefore the long-term sustainability of the surgery as a whole. I have highlighted core document 12.4, general practice workload pressures by the BMA, who have highlighted under-resourcing as a cause for GP surgery closures. We have clearly set out our concerns in detailed data. The appellant has not modified their proposal to address any of our concerns. They simply assert that the care needs of the residents will be lower than we predict based on our extensive experience within this community. We have not seen any qualified medical advice from the appellant to support their assertions. We have not seen any evidence to back their assertions that the level of care will be low and manageable, and in fact, in cross-examination, have confirmed that there is no method whatsoever to control the level of high-level care needs residents in this development. This development is not driven by local need, but greed. No one is a winner apart from the landowner. Anyone with local knowledge can see this planning application is wrong, and anyone can see that Bottisham does not need and will not benefit from any more elderly care housing of any description or variety, however it can be manipulated to look helpful. This location is not sustainable for any further elderly care housing of any type. National policy states it is that very special circumstances have to be proven to build on greenbelt land. There may be very significant need for extra care housing in East Cambridgeshire District Council area. However, there is no very significant need for extra care housing in Bottisham itself. A village with a population of only 2,100 has no requirement for extra care housing of 255 residents, more than 10% of the village population, when we already have more than 10% of the population of the village in care home beds. We can see no evidence of very special circumstances to allow development on this greenbelt land. Development cannot claim both to have residents of low care needs and to be marketing to NHS continuing care residents. These two statements simply do not align. These units will be for sale on the open market for elderly residents, age being the only qualifying factor. There is no limit to the number of high care needs residents. I leave you with one final thought to reflect on. At the case conference to plan the outline of the inquiry, the majority present wanted to have the inquiry held in person, face to face. I expressed my concern with this view and thought I would be surprised if at least one of us would not have COVID at the time and thus risk the health of those present. Fast forward 2 months and 3 of us are known to have had COVID during this 2-week period. As a GP, I am able to predict medical outcomes in a community. There has been no witness present other than myself with any medical qualification. I have the knowledge and experience to predict the impact that this elderly care development will create on the community of Bottisham. Please remember, this is permission for a healthcare facility. After all, it's designed for elderly people with care demands and thus healthcare needs. We are asking for the planning inspector to uphold the current refusal in planning permission. We feel very significant weight should be given to our views, given that this is planning permission for a healthcare facility, accommodation with on-site care for elderly residents with care needs, and thus would need the agreement from the local GP surgery to offer the care required. We are not in agreement. Bottisham Medical Practice strongly oppose the proposed development on the basis it will overwhelm the primary care service that we provide. Thank you.
Thank you very much, Dr. Keith. And I have now received the written statement, so thank you for that. And I've also received your statement, Mr. Simons.
Good, sir. Are you content for me to press on?
Yes, I am.
Excellent. Thank you very much. Indeed, certainly am. Right. Sir, for all of the documents before you, the key issues in the appeal are now simple, and many of the important points are actually agreed. And in particular, the council agrees with the appellant that if the scheme's benefits clearly outweigh its harms, you should allow the appeal and grant planning permission. Ms. James accepted that her own attempt to strike that balance had omitted important benefits and so was inappropriate. It cannot be relied on. It's an important point, and I return to it later on. The council accepts that the needs for private extra care and also, of course, for affordable housing in East Cambridgeshire are acute, Ms. James's words, and she also accepts that the council claims a general 5-year housing land supply, which for the purposes of this appeal is, of course, not disputed. Does not, it is agreed with Ms. James, tell us anything about these enormous shortfalls in the delivery of both specialist and affordable housing. And the council concedes that across this district, important government objectives are not being met, including that of ensuring that a sufficient number and range of homes can be provided to meet the needs of present and future generations. That's paragraph 8 of the framework. And it concedes as a matter of principle, come back to this, that its local plan does not seek to preclude a scheme like this coming forward adjacent to the settlement boundary of Bottisham. It accepts that landscape and visual impacts are restricted to the site itself and its local surroundings. There's no heritage reason for refusal. Again, more of that just in a moment. And it also accepts that this is a locationally sustainable site for our scheme in terms of easy access to an appropriate range of facilities. And I just note in this footnote, so I won't read them all out, but I'll just note that that was accepted by Ms. James in her evidence. In particular, you'll remember she agreed that we accorded the first bullet point of housing 6. Surprisingly, I say the council throws some points on locational sustainability into its closings. Paragraph 31, things like availability of dentist services and a train station. This, with respect, we say is a very odd point for the council to take when we agree that you shouldn't notionally close your eyes to the existence of, I should say Cambridge rather than Cambridgeshire, Cambridge, the county's most important city, only a few miles from our site. Anyway, back to the text. There are, of course, no other technical constraints to deliver it, which is why in the end we will say the balance is actually straightforward. The benefits associated with the scheme are very substantial indeed, and its harms, such as they are only modest, and the framework requires us to give any harm to the Greenbelt substantial weight in the balance. But even then, this is a case where the fantastic and much needed benefits clearly outweigh the scheme's modest harms, which means in the end that we're supported by 148 of the framework, and therefore the appeal should be allowed. So I start, sir, with the proposition that the benefits associated with the retirement care villages are profound. At the heart, sir, of the government's social objective of sustainable development is the need, as I've said already, to ensure that a sufficient number and range of homes can be provided to meet the needs of present and future generations. Now, that allies with the government's imperative of significantly boosting the supply of homes by bringing forward a sufficient amount and variety of land where it's needed, so that the needs of groups with specific housing requirements are addressed, and that land with permissions develop without unnecessary delay. Now, that includes, of course, the framework tells us, the particular needs to plan, both for those who require affordable housing and, of course, for older people as well. That feeds into the planning practice guidance for housing for older and disabled people, which begins by stating that the need to provide housing for older people is critical. Now that's an important starting point for this appeal. In policy terms, the government is clear that all kinds of market and affordable housing are needed. Of course they are, but it's this need for housing for older people, and indeed only this need, which is described as critical. As Mr. Belcher and Mr. Snedden explained, that's not some sort of accident. Those who need this form of accommodation, by definition, they need it now. The PPG describes the kinds of specialist housing proposed in this scheme in one of the bullet points of paragraph 10, extra care housing or housing with care, and you've seen that a few times, I won't reread it. The benefits associated with retirement villages are very well evidenced, and there's a raft of stuff before you, and the contents of it all is unchallenged. And I'll give you just four or five of references to the documents that you've seen. And those documents explain that extra care leads to very significant improvements to residents' exercise, to their perceived health, to their independence, to their walking speed. It includes reductions in risk of falls and frailty. Residents' life expectancy, remarkably, increases not just by months, but sometimes by several years. In terms of psychological well-being, extra care reduces levels of depression, anxiety, loneliness and isolation. It leads to improvements in memory, improvements in cognitive skills, and residents report a considerably improved sense of their own quality of life. In addition, residents make more effective use of healthcare resources, reducing visits to GPs, reducing ambulance call-outs, hospital stays, making more efficient use of care workers. Residents average several days less per year in hospital, and that's a good thing in general, but it also saves the NHS thousands of pounds per resident per year. This means the NHS, of course, would have extra money and resources with which to tackle a range of other urgent health challenges. Extra care accommodation has coped particularly well with residents having fared better than those of the same age in the wider community during the COVID pandemic. So it's no surprise to see this model at the heart of the government's plans in the recent social care white paper. And to be clear, all of those benefits that I've just rattled through, they're all accepted by the council. None are challenged. They've been consistently given significant or substantial weight in a raft of appeal decisions, and there are lots, but I've given you a couple of examples, including the St Albans decision just literally, I think, 2 or 3 days ago, whenever it was. Ms James, for the council, acknowledged that these were important benefits, but she also agreed she'd omitted them from her planning balance. And the benefits don't stop. They don't stop there. Almost 90% of older people in East Cambridgeshire live in homes which are under-occupied. And this is a critical challenge for the council. Its own advisors, which is to say GL Hearn, have told it that making more efficient use of its existing housing stock would reduce the requirement for more housing land, and retirement villages are a solution to this problem. That point's been endorsed by experienced inspectors in other appeals. I've given you an example there of Christina Downs, who said that, and again, she gives it significant weight. I won't read it all out, sir, but you've seen those paragraphs in her decision where she sort of goes into that. And again, there's a similar analysis in the St Albans appeal just the other day. You've got a reference to that. Now, Ms James, for the council, accepted that there are very considerable benefits both to the residents of retirement care villages like this one and to the broader community, but she doesn't weigh those benefits like freeing up the family homes, healthcare, wellbeing benefits, all the rest of it to residents. And that renders the council's approach to this scheme unsafe. And again, I return to the implications of that below. On Dr. Keith's concerns, she's obviously listening to this, but she won't mind me saying, I hope, a very clearly, to us anyway, very, very conscientious GP who clearly cares very deeply about her practice and is concerned with stopping too many new people moving into its catchment area, as she's explained. Her medical qualifications are, of course, not in any dispute, of course. But she has no expertise which is relevant to the issues that you have to decide. In particular, Dr. Keith has no professional expertise in planning policy, planning law, operating retirement care villages, or planning needs assessments for the extra care model. She's got no professional involvement in or expertise of the raft of policy and research, into the retirement care village model. So again, with respect, with genuine respect, that lack of relevant professional experience went right to the heart of her evidence, because she repeatedly said there's no material difference between the appeal scheme and a care home, and that's the fundamental premise of her case, as she explained in cross-examination. But that's wrong. It's not a matter of debate. It's proven. The distinction's not only recognised in the PPG, but the various benefits of a retirement care village, including to GP surgeries and to the NHS more widely, are demonstrated by evidence which has not been contested. Her other assumption, also wrong, was that planning obligations would be fruitless at this stage because the operator has still not been confirmed, which it still has not. But of course, a planning obligation will bind the future operator, whoever they are, and this error has led to a failure of Dr. Keith's practice to engage with ways of addressing her concerns. In the end, of course, the real issue wasn't one for the town and country planning process, but for the CCG. And it became clear that Dr. Keith and her partners have real frustrations and difficulties in communicating with their CCG. But that, again, with respect, has nothing to do with us, nor does it involve the development management process. The population, not just of Bottisham, but that of the district as a whole, is already older. And as we've seen, is the GL Hearn report, it will continue to grow and to age with or without our scheme. It's the legal function of the CCG to treat that population and to ensure that appropriate resources are allocated to ensure that can be done. If there is, as Dr. Keith contends, a particularly old population in Bottisham, that makes this location more, not less, appropriate for a retirement care village to accommodate that population. Because of the benefits to the healthcare system associated with our scheme, and because of the CCG's role in the strategic planning for resource allocation across GP surgeries, there's no necessity for a contribution towards the Bottisham GP practice. Nonetheless, at the 11th hour, after months of chasing, the CCG's finally requested a financial contribution, and it said that such a contribution will accommodate increased staff, patient and resource capacity, or improvements, could be in the form of an expansion to the existing practice, financial contribution to a future new facility in the area to meet demand. That's what the CCG have proposed. To be reasonable, albeit, as I've just said, we don't accept the necessity for that contribution, and albeit it's not been requested by the local authority, it's now been offered, and you've heard all about that this morning, so I won't go back over it. We do note the lack of any evidence of any relevant planned capital expenditure, expansions, or new facilities to which this money would be put. But nonetheless, broad language, as you've seen, will be included in the planning obligation, which covers this proposal. It could be spent on any number of things, including, as you've heard, staff resourcing as well as physical infrastructure, if they decide to. You can reach a view on, you will reach, no doubt, a view on the necessity for it in your decision. And in effect, that is an end to the CCG's request. And for completeness, the evidence does not support the necessity for or quantification of any further contribution to deal with any ongoing quote-unquote clinical needs. The CCG have had many opportunities to provide evidence on what such a sum would be, and even now, they've not. They support Dr. Keith's concern as a matter of principle, but they don't actually evidence specific requests for a legally or policy compliant figure. And they accept that such a quantification is not even possible at this stage. And indeed, the recent email, very recent email of Mr. Ching from the NHS Property Services makes the same point, which is that an ongoing revenue contribution based on Dr. Keith's evidence cannot, his word, be progressed in a way which accords with the relevant obligation in the SIL regs. And unfortunately, sir, as I said earlier, this takes us to the limit of what the town and country planning system can achieve, because the law and the NPPF require all of us, only to require contributions from developers which are necessary and which are proportionate to the scheme before us. In the end, as I've said, there's no request for a contribution from the council. There's not for a further contribution from the CCG. No evidence at all suggests the scheme would be unacceptable in planning terms, having regard to the general obligations outside the planning system for the CCG to treat its patients. And with respect, it's not for specific developments to invent numbers on a sort of ad hoc basis. We've got no involvement in the CCG's strategic planning functions. The CCG reviews Dr. Keith's practice, as well as all of its other practices, on a regular basis. And if more funding is required, it's a matter for the CCG and its resource allocation policies. It's not a planning matter. If it really is the case, that in order to achieve a planning consent, residential developers in East Cambridgeshire are required to make annual, ongoing, unquantified, unquantifiable contributions, which haven't even been requested, still less quantified by the relevant consultee, towards their local GP surgeries, then the challenges for development management in this area are going to go much wider and deeper than this scheme. I turn next to a different heading. The need for private extra care in this district is acute. The council agrees that the need for a retirement care village like this one is not significant or substantial. It is acute. And given that point of agreement, you need, I think, in a way, not to get entangled in debates about detailed methodology. Ms Venables has adopted a tried and tested approach, which derives a gross need for private extra care by applying a percentage of the overall over 75s population. And the position summarised neatly in her table 2, giving you a reference to it, taken together with the key figures from their GL Hearn report. The headlines are that in 2019, there were 18,340 over 65s in East Cambs. That's going up by almost 60%, over 10,500 people by 2040. And the vast majority of those people will own their own home. It's important because it means that they won't qualify for affordable housing. And as Inspector Catchpole said in the Bath decision, homeowners, in that case comprising over 66% of older householders in the council area, won't be eligible for future affordable extra care developments. It follows, he said, that a significant uplift in provision is needed to ensure equitable access to improved health outcomes for all individuals, irrespective of their financial status. Well, that was the case there, but of course it's the same here. So Ms James accepted for the council there's a significant proportion of older people in this district, and that population is going to increase substantially, and the vast majority of them don't qualify for affordable housing. The government's view is that increasing supply of specialist housing to cater for this ageing population is a critical priority. So far as private extra care is concerned, adopting industry standard ratios, and as of 2025, which is the year that our scheme would become operational, Ms Venables' evidence is there'll be a gross need of 418 private extra care homes in East Cambridgeshire. To meet that need, there's a single scheme, just one, Roslin Court in Ely, just over 12 miles from our site, so well outside its market catchment. That scheme is not a retirement care village like the one on offer here, but it does include 57 units of private extra care. 57 units, that's it. That's the only scheme in the district to meet this critical and quickly growing area of need. How many schemes in the planning system are awaiting a decision, other than this one, of course? 0. How many have been granted permission and are awaiting construction? 0. How many sites are allocated for private extra care? 0. I'll come back to that point in a minute. So arriving at this district's net figure for need is happily pretty simple. You take the gross, which is 418, minus 57, which is Roslin Court, and there you have it, 361 homes required by 2025. In the end, as James for the council in cross-examination agreed, there's an acute and growing need for private extra care accommodation in this district. The PPG says it's critical to meet that need, and the council is failing. It's failing to meet these needs, and that brings it into conflict. She agreed with critical objectives in the framework. There's no short to medium-term prospect for addressing that need and through the plan-led process. That is because, as Ms James also accepted, the local plan makes no express allocations for extra care. In those circumstances, sir, the raft of appeal decisions in the core docs support giving at least substantial weight to the delivery of specialist housing. We've got a couple of examples. This has been dealt with elsewhere, and there's lots more in Mr Warner's proof, pages 36 to 37. And to those examples must now be added the recent St Albans appeal, as you've seen. The weight should be substantial, irrespective of whether or not the council can demonstrate an overall 5-year supply of housing land. And that's a point that you can take out of Christina Down's decision and Hazelden's nursery, where the council could, in that case, demonstrate a 5-year supply of housing. And of course, that makes sense, because as Ms James agreed, the overall 5-year housing land supply metric tells us nothing about the extent to which councils are meeting their needs for specialist or affordable housing, which makes it an odd point for the council to lead off with in their closing submissions, which you've just heard. And the benefits of providing specialist housing should be weighed, as James agreed to this proposition, separately from and in addition to the general benefits of this scheme's contribution to housing land supply. And that's how it's been approached by lots of other inspectors elsewhere. Ms James agreed that that's how you should do it, sir, in this appeal. It's agreed. But of course, she hadn't. She gave only limited weight to the overall benefits of the contribution to housing land supply of our scheme. And she gave no particular weight at all to the scheme's provision of specialist housing. Again, that rendered her analysis unsound, as she ended up accepting, to be fair to her. And I'll return to the consequences of all of that in a moment. Now, next point, sir, is that there's no evidence of any available, suitable and deliverable sites for our scheme. It is easy not to see the wood for the trees here. There is no evidence of any other site before you in the district or the relevant market catchment area which is suitable, available and achievable for accommodating this scheme. None. None. The function of an inquiry like this one is to test evidence, not speculation, not assertion, evidence. And the council's not got any. In particular, Ms James asserted that, quote, this type of accommodation can, so she said, be accommodated elsewhere. And she said, as such, very special circumstances don't exist. That was her evidence. That was, she told us, an important step in her analysis that no such circumstances exist, although I'll come back to the flaws in her overall analysis of the planning balance later on. The type of accommodation she had in mind, she confirmed, was a retirement care village of the sort that is proposed here. And yet, she's got no professional experience of this kind of scheme. She doesn't tell us how many other sites she has in mind, where they might be, over what period they might be developed, whether they're suitable, available, or achievable. And I suppose most important, sir, she doesn't actually tell us whether the other sites she apparently had in mind would actually meet the acute need which Ms Venables quantifies and which Ms James accepts. With respect, that is vague and it is unevidenced assertion. It's nothing more. And the fact that the unevidenced assertion, we're told, plays an important part in Ms James' overall analysis of the appeal should concern us. Not only that, albeit the council's taken a series of pot shots at Mr Belcher's industry standard methodology, it's produced no evidence at all which proffers an alternative methodology. If it doesn't like, for example, his 3-year timeline for delivery or his size parameters, it would have been incumbent on the council to present evidence to you on why not and what appropriate parameters would be. Now, it's chosen not to do this.
Mr. Simmons, it's back.
Sorry about that.
Momentarily.
Let me just make sure that that's not going to happen again. Sorry about that. Now, they have chosen not to do this. They've chosen not to do it in writing, which could have been obviously through a rebuttal to the ASA once they'd received it. They've chosen not to do it orally in Miss James's evidence in chief. That was their choice. And it was taken, no doubt, because, as Miss James explained, she does not have the professional experience or expertise to gainsay Mr. Belcher's methodology. Now, so be it. There's no criticism there, of course. But that does mean that Mr. Belcher's evidence is substantively unchallenged. So this is a simple case. You've got one party who's presented a detailed and transparent alternative sites assessment, and you've got another party which apparently doesn't like the answers that ASA has produced, but which has given you no evidence to support reaching any other conclusion but that within the ASA. And again, as I say, the function of an inquiry like this is to test evidence. And again, even after all the various sites the council's now tried to crowbar in through its opening statement and through its cross-examination of Mr. Belcher, it has still, even now, as we close this inquiry, been totally unable to identify any appropriate alternative. That is a telling failure, and it supports the robustness of Mr. Belcher's conclusions. And remember, given the acute scale of need, we're not just looking for one site or two sites. This council needs several sites providing private extra care to address its spiralling needs. And of course, it's not identified even one. In the end, Ms. James's evidence to this inquiry, and this is adopting the language of policy How 6, her evidence is to you that the need, she says, which exists for private extra care, she says that need is likely to be met in built-up areas, likely. And again, you know, with respect, how on earth can she make that assertion with no allocations, no schemes in planning other than us, and none consented? She can't. The council has spent most of its time lamenting the lack of an alternative sites assessment at the application stage, and we get more of that in the closings that you've just heard. Irrelevant. The ASA before you is either robust or it's not. And that's got nothing to do with when in the process it was submitted, but it's also misplaced. Because if the council wanted an ASA at the application stage, you just had to ask. There's no requirement, as Mr. Smith continues to imply, to supply an ASA at the application stage, that it has been supplied in other cases where the relevant councils did require one at the application stage. Again, with respect, it's just totally irrelevant. The ASA which has been provided and explained by Mr. Belcher is a detailed and careful piece of work, and it adopts a conservative approach. To take size as an example, the scheme's footprint is 4.8 hectares. And given that the function of the ASA is to identify another site for this scheme, looking for sites of 1 to 2 hectares is pointless. Nonetheless, Mr. Belcher expanded the search to the industry standard 3.5 to 7.5 hectares, which is the range required by major operators in this marketplace. See the letters from the operators appended to his proof of evidence. That is not, as Mr. Smith says, some kind of generic criterion. It's evidenced standard market practice. And Mr. Smythe's, criticisms of that criterion has the disadvantage of not being backed up by any evidence at all. Further, Mr. Belcher's criterion of delivery within 3 years is robust when, firstly, this scheme will, if you grant permission, sir, be delivered within 3 years. And it's this scheme which is the focus of the ASA. And secondly, it's Ms. Venable's evidence on need is focused at 2025, 3 years, which is when this scheme would be delivered. And that's the need that this scheme is seeking to address. And of course, adopting a 3-year period recognises the urgency of the need, which the council agrees is acute. Mr. Smythe suggests, and again, he doesn't have any evidential support from Ms. James or anyone else for this, that a 5-year period would have been more appropriate. But why? There's nothing in the framework, the PPG, to suggest that specialist housing should be considered in 5-year increments. None of the planners in the case have suggested a 5-year timeline is appropriate. It's just him. And of course, the general 5-year housing land supply mechanism is a totally separate policy device. Why, as Mr. Belcher put it, if we acknowledge an acute and growing need, which the council does, of course, with no planned provision to meet that need, should the council suggest pushing any chance of meeting that need into the second half of this decade? There's no answer to these questions from the council because, of course, they produced no evidence at all on this topic. There was no requirement for Mr. Belcher to approach the council before finalising his ASA. And the real point is such an approach, and we now know this, it's not a speculation, it would have been totally futile because the council does not know of any alternative sites for this scheme. and because it lacks the professional expertise to engage on an appropriate methodology for the ASA. And there's no dispute about that, sir, because their lack of relevant expertise is confirmed in Mr. Smythe's closing statement, i.e. the council doesn't have the time or expertise to scrutinise the whole ASA. And if that is so, what on earth would have been gained by forcing the applicant to agree the ASA with the council? We see that lack of experience from the sites the council has now tried to crowbar into the inquiry, in particular, firstly, Clare House in Dullingham. That was covered in the ASA. And of course, it's got a consent. It's got a consent for C3 residential, on the recent advice of the developer, the council anticipates that's coming forward within the next 5 years. We find out today that the council's strange eagerness that the permission might expire was misplaced. Reserve matters are in. So again, you know, with respect, we get a whole paragraph on the site in Mr. Smythe's closings on how we erred by omitting it. But it's a site with permission which is being delivered for something different. It's not an alternative site. It was considered and omitted. That it was considered and that it was omitted is a testament to the robustness of Mr. Belcher's work. He was right. The major strategic allocations in Ely and in Soham that are not allocated for extra care, and as the council's latest housing supply statement confirms, won't start delivering for many years. Ms. James suggested there's nothing to stop extra care coming forward on these major mixed-use residential allocations. But again, with respect, that shows her lack of experience in this marketplace. She could unsurprisingly find no examples where extra care had actually been delivered on general residential allocations in this district, and offered no reason to disagree with Inspector Clark, who said in Stapleford that uncontested evidence given in this appeal is that unless sites are specifically allocated for C2, developers are unable to compete for sites. Sorry about that.
Yeah.
I'm sorry, it keeps, 1 moment. Don't know what's going on there, sorry, technical issues. That said that the developers of such schemes are unable to compete for sites in the housing land supply market with providers of general C3 general housing accommodation, and so the delivery of C2 development will be restricted. Ms. James suggested repeatedly that this council makes no distinction between C3 and C2, but of course that's totally wrong. Its housing report deals separately with dwellings coming forward on allocated sites and other older people's accommodation, C2. Ms. James didn't seem to have noticed this until I showed her in cross-examination. And the final site that she mentioned was Blackberry Lane. That too was picked up and analysed in the ASA on page 23. And the council's own recent analysis shows it's not deliverable until later in the plan period. And the council's final point is that the appeal site exceeds the 7.5 hectare size filter. But that is, again, you know, with respect, not a good point. The area of the appeal site which will actually contain the built development falls comfortably within the relevant size parameters. For the purposes of the ASA, that's what counts. The overall site does exceed 7.5 hectares, but it only does that because of the very generous and far above policy compliant provision of public open space. I'll return to that issue below. And in the end, Ms. James agreed. The council does not, even now, proffer any of these sites or any other sites as suitable, available, and achievable alternatives which could actually accommodate the appeal scheme, which you might have thought is a pretty strong indication, not only that Mr. Belcher's methodology is robust, but that his conclusions are correct. So I turn next, sir, to the council's own case that its local plan supports private extra care outside settlement boundaries. The council's main theme in its opening was all about the importance of policy growth too in the local plan and how our scheme would apparently conflict with that important policy. It's a strange theme to pursue when Ms. James's evidence was that this policy does not seek to preclude new schemes coming forward outside the market towns. It expressly allows for certain categories of new development to come forward outside settlement boundaries. And in Ms. James's view, both elements of our scheme, the affordable housing and the retirement care village, forward in those categories. Ms. James agreed in cross-examination that Grove 2 is capable of supporting this appeal. Whether it does or not depends on the criteria set by other policies, and in particular House 6. Now, of course, there's a dispute between the planners on the interpretation of House 6's second paragraph. Ms James reads its reference to care or nursing homes as applying to our scheme, as you've heard, which she agrees, of course, our scheme's not a care home and it's not a nursing home either. But if she's right about that, if she's right, then whether we accord with House 6 and by extension growth 2 depends on those 3 bullet points in House 6. If she's wrong about that, then this is a plan which makes no provision at all for the supply of extra care housing, in particular on sites outside development envelopes, with the consequence that you should give any technical conflict with that policy only a limited weight, because the plan is failing to and has no mechanism to address needs which the council agrees to be acute and growing. But on those 3 criteria in House 6, on the first one, Ms James agrees our site is located, adjoining or in close proximity to a settlement which offers a range of services, facilities, and there's good accessibility by foot, cycle to those facilities. An important point, of course, because it is agreed this would be a sustainable scheme on a sustainably located site. The second bullet's character and appearance is dispute, of course, between the parties, and I'll come back to that in a moment. The short answer is there's no harm to the setting of Bottisham as a whole, or to the, quote, surrounding countryside, language of the of House 6. More widely, the effects are localised to the site itself and to the immediate surroundings, so the policy test is met. A reading of that policy, which only allowed schemes to come forward if they have no impact at all, would be totally incompatible with the more nuanced, balanced approach in the framework, and it would be self-defeating for a policy which is all about exception sites where some level of landscape impact will always arise. Again, I'll come back to that in just a moment. On the third bullet, Ms James agrees there's an identified need for such provision. As above, her evidence is that the need is that need is likely to be met within the built-up area, but as we've said, that was in the absence of any applications, any permissions, any allocations. It was, Ms James told us, an aspiration. Well, that gives the game away. I'm sure we'd all commend this council aspiring to deliver more extra care homes, both in the built-up areas and in other areas too. But aspiration is not evidence. Still less is it evidence that delivery within built-up areas is likely. So, the need for affordable homes in this district is acute. Again, sir, the council agrees that the need for affordable homes is acute in the district. The numbers tell a tragic story. Needs unmet year after year for some of the most vulnerable in our society. In particular, sir, this district should have delivered 1,760 new affordable homes in the decade from 2011 to 2021. In that period, gross completions, so not net, gross completions are only 479. That's a shortfall of 1,281 homes in just over that decade. And of the total need of 1,760 homes, almost 1,300 of that total need has gone unmet. And all of this, of course, is to say nothing of the need for another 1,760 homes between 2021 and 2031. These are important needs. They're the needs of some of the most vulnerable in our society, and it's easy to sort of glaze over with all these statistics. But these are, as the Secretary of State has said in other appeals, these are real people in real need now. Their interests are being let down by the planning system in this district. Ms James agreed that this position is unacceptable. The needs are acute. The picture is bleak. And all of that suggests that this scheme's delivery of a substantial number of affordable homes should be given no less than substantial weight in the balance, as it has been elsewhere in reams of appeals. And so, for a primary example, Krista Masters' approach in the Colney Heath appeal, where she said that the persistent undelivery of affordable homes there presents a critical situation. She attributed it very substantial weight in the very special circumstances balance there. So, how did Ms James for the council deal with this mission critical issue? Well, she appeared to attribute substantial weight to the scheme's delivery of affordable homes. But then she reduced and then increased again and then re-reduced that weighting on the stand for a number of reasons. First, she said the scheme's provision of affordable homes is policy compliant. She never explained why that should result in reducing the weight to be given to those homes. It obviously shouldn't. The council's affordable housing policies are designed to achieve an important social benefit. Our scheme's contributing to that delivery. There's no logic in reducing the weight of the contribution when the whole point of the policy is to secure the very benefit that we are delivering. Then Ms James reduced the weight to be given to the affordable homes to moderate on the basis that the council, quote, aspires to put affordable housing in other parts of the district. With respect, that's not good enough. That's not nearly good enough. The council needs many, many hundreds of affordable homes now, not just in Ely, not just in Soham, but wherever they can be sustainably located, and they can be, the council accepts sustainably located in Bottisham. She could point to no other decision of the planning inspector or the Secretary of State which has given the provision of affordable housing only moderate weight, and it would be particularly shocking to find such a conclusion where the provision on offer is substantial, it is policy compliant, and where the needs for that provision are recognised as being acute. In the end, Ms James accepted she'd not given appropriate weight to the delivery of affordable homes in her evidence because she had baked into that weighing other criticisms she had of our scheme. She accepted this meant she'd not addressed the overall planning balance properly. Again, I'll return to the implications of that in a minute. Our scheme's substantial provision of affordable housing also puts light to the criticisms of some members of the public that this is a skewed scheme, that it makes older people a disproportionately large part of Bottisham's population. There are two answers to that. First, the district's population as a whole is already ageing fast, and that's with or without this scheme, and the imperatives to find a way to house that ageing population appropriately. But second, the criticisms ignore this provision of affordable homes, which will by their nature be accessible to younger people, to young families, to those in need. This is a balanced scheme. Its mix will support Bottisham's future as a well-balanced community. Next, sir, I turn to why this scheme will sit acceptably in its local landscape, and turning first to landscape effects and then visual. On landscape effects, the landscape is not subject to any national, regional or local designations. It is, the parties agree, not a valued landscape within the meaning of the NPPF. And the starting point is to derive an objective and robust assessment of the site's value. It comprises two pleasant but unremarkable fields. Those fields, as you've seen, have different characters. The northern field is a very ordinary, arable field. It is a flat, featureless field, bounded and closely trimmed, but bounded by closely trimmed hedgerows. Built developments, prominent views to the northwest, to the southeast, and overall, there's nothing special about it, and certainly nothing that elevates its value above ordinary everyday countryside. It has a low value. Looking beyond the northern field to the adjoining countryside, you see a continuation of that unremarkable character. Flat, featureless, closely trimmed hedgerows. That's the immediate rural context of the scheme, and it's got no particular value. And that's important, sir, because it's this northern field, an area of low value, which is where most of the built development in this scheme will actually happen. The southern field's different. It includes groups of mature trees. It's got closer relationships to the built-up area of Bottisham. It's unremarkable in other respects, but those aspects bump it up to a medium level of value. And Mr. Brown for the council puts the whole site at a medium to high local value. And again, with respect, that doesn't make sense. And his methodology doesn't seem to explain how he arrives at that judgment or what it actually means. As Mr. Crawford explains, there's nothing that elevates this site above a community value. Almost all landscapes are valued by somebody. There's nothing which gives the appeal site a value beyond or above that community value. And albeit Mr. Brown accepted during the roundtable session that the site's not of national or regional importance, that wasn't reflected in his landscape methodology. The scheme doesn't meet any of the relevant criteria in the guidance to suggest this higher level of value. The key points of difference are that the council's approach relies on an intrinsic link between the characters of the northern and southern fields. But as you've already seen on site, the sites are quite separate. in their character. And second, the idea that the southern field is, quote, parkland, but it's not. It's a grazing field which has mature trees. On the site's susceptibility, its ability to contain the scheme and to what degree the scheme would change the key defining characteristics, Mr. Brown tried to emphasise the views out, you'll recall, from the southern field to the north as some sort of defining characteristic. But again, so, you know, with respect, that doesn't stand up to scrutiny. The southern field draws most of its character from the trees in it and from its proximity to the village edge. Those elements be generally unchanged, surrounded already by built development on three sides. And of course, that development too affects its character. The field pattern in the northern field would be unaffected. So on the overall significance of landscape effects, the experts agreed that the focus should be on the position at 15 years post-construction, and that only effects of moderate or higher significance should be regarded as quote unquote significant, and that's likely to inform your decision. That allows for new planting to be established, which will soften views, 15 years does, I should say, which will soften views, mitigate the impact of the development on the character of the adjoining landscape and produce a boundary treatment more in keeping with the wider landscape. And as Mr. Crawford explained with reference to the detailed method in the LVIA tables, the site as a whole, which is to say both fields, will have only minor overall impacts and below the significance threshold for harm to have any impact on the planning balance. For the wider landscape character area, the planned peat fen, there's no significant adverse effect at all. Even on Mr. Brown's case, the landscape effects are no more than minor when considered in the context of the wider countryside surrounds rather than just the site itself. And the critical point here, sir, is agreed between the parties. The council accepts that what effects there will be on landscape character are highly localised to the site itself and its immediate surroundings. So with that, sir, I turn on to visual effects. In the end, sir, even with Mr. Brown's extra viewpoints, which with respect add nothing material to the other viewpoints in the LVIA, the main parties agree that the scope of visual effects associated with this scheme are limited. So far as residents are concerned, there'll be moderate impacts in relation to homes to the south and the west. The changes to this field will be limited to the construction of the access road and new planting. The mature trees, which are its most important feature, will be retained and enhanced by successional planting. The retirement care village, yes, will be seen, but generally seen at a distance. Mr. Brown sought to make much of Bottisham House. But there's no basis at all to take a different approach to the receptors of that property than anywhere else. He was allowing heritage considerations to infect his analysis when the council takes no heritage objection as part of this case. I'll come back to what they say about heritage at the end. There will, as Mr. Crawford explains, be major impacts to residents and affordable housing proposed to the northwest of the northern field. The impacts will again reduce the distance. So the impacts from ancient meadows around 300 metres away will only be moderate. For users of the footpaths, the impacts will be moderate, and in the latter case, negligible once you pass through the hedgerow to the north of Mr. Brown's viewpoint 1. With respect, Mr. Brown's evidence on this was confusing. It was confused. He tried at the round table to inflate his conclusions on that one, but he was forced to retreat when it became clear that it would totally undermine the credibility of the rest of his assessment. And at times, again, with respect, he was making it up as he went along. But the key headline is a matter of common ground, because overall, the experts agree, with one exception, that the only significant effects will be experienced for residents of houses immediately adjacent to the site and the short length of little used public footpath immediately adjacent to the site. But as Mr. Crawford explained, that's going to happen with any village extension anywhere. The only significant effects beyond the immediate vicinity of the site are moderate effects, so of lesser significance, 7 houses and users of 200 metres of public footpath around 300 metres away. There's no other visual receptors within the surrounding landscape or village which would experience significant effects. And again, that's not just our side, that's common ground. So that is, as Mr. Crawford put it, an extremely low level of effect for a greenfield development at the scale, which takes us to the policies, sir. Because of all of that stuff, the scheme accords with ENV1 and to the extent it's relevant at the outline stage, ENV2. And for a detailed point-by-point summary on the correct analysis to those criteria, you've got all of that in Mr. Crawford's evidence. For the same reasons, the scheme reflects the policy requirement in the framework to recognise the countryside's intrinsic character. Recognise does not, of course, mean leave unchanged or avoid any impact at all. It's quite different from the requirement at 174A of the framework to protect valued landscapes. And of course, the parties agree that this is not a valued landscape within the meaning of that paragraph. Policies House 6 and Growth 2 both allow certain kinds of development outside settlement boundaries. so long as they wouldn't cause harm to the character of a setting, of a settlement, or the surrounding countryside. Or, in the language of Growth 2, there's no significant adverse impact on the character of the countryside. Now, we've got to approach those policies carefully. If read in a literal blanket way, they'd be self-defeating, and they'd also be inconsistent with the NPPF. They'd be self-defeating because by their very nature, exception schemes would only ever come forward outside settlement boundaries. So there'll invariably be some level of landscape impact in one way or another. They'd be inconsistent with the framework because that requires us to balance whether landscape and visual harm arises against the scheme's benefit. So, if read in that way, any conflict with these policies could only be given limited weight. However, they need not be read in that blanket way, because as Mr. Crawford explained, the policies focus on the wider character of the settlement, which is to say Bottisham, and of the surrounding countryside, and Growth 2 applies only to significant impacts to the character of that countryside. These policies require there to be a finding of harm which extends beyond the site and its immediate surroundings, but as above its common ground, that the significant landscape and visual impacts will be restricted to the site itself and to its immediate surroundings. And so I turn to the green belt, and the integrity of the wider green belt will be unaffected. And turning first to the green belt purposes, and remembering, of course, Ms. James alleges that all of them are conflicted with. There are 5 of them. The first one, Bottisham, is not, she agreed, a largely built up area, so it's irrelevant. The site plays no role in constraining the sprawl of Cambridge either. Bottisham, on the second one, is a village, it's not a town, so the second purpose is irrelevant. But in any event, this site will not lead to any settlements merging into one another. There will, of course, technically be some quote-unquote encroachment into what's currently deemed open countryside. But as above, there'll be no harm to the wider countryside, and most of the landscape effects will be perceived only from the site itself and its immediate surroundings. There'll be no harm to the setting or special character of Bottisham as a settlement, and our scheme will have no impact one way or the other on assisting in urban regeneration. We've got no good explanation as to why this purpose was even vaguely relevant, still less why it was breached. And of course, the council's not identified a single derelict urban site which is available, suitable or deliverable for our scheme. Turning to openness, there would of course be built development on what is now a field. The site will inevitably be less open with our scheme on it than it is now. But that new form would only be perceived on the site itself and its immediate surroundings, that the character and spatial function of the Greenbelt parcel as a whole, totally unaffected. And albeit the council's case was predicated on there being substantial harm to openness, that wasn't evidence. The wider rural setting of the village will remain intact. The stronger rural character of the remainder of the Greenbelt parcel and the landscape northeast of the village will be retained. And in the end, the integrity of the wider Greenbelt parcel will be unaffected and its spatial functions will be preserved. So, with all of that, I turn to the overall planning balance. As I have said, the government tells us that meeting the need to provide housing for all the people is critical, and that these needs should be met with a diverse range of accommodation choices, including what the planning practice guidance calls extra care. And as we have explained, a care village like this one will offer residents a chance to downsize or right-size from their previous home into private extra care housing in a purpose-designed community setting to better suit their needs as they age, and the knowledge that should their care requirements change, their home will not. Retirement care villages like this, and as you now know, so they're already common in America and in Australia, but they're still an emerging product in the UK. They bring with them a massive range of benefits, mental and physical health and well-being of residents and the wider community, including enormous financial savings to the NHS. Those benefits are recognised not only in national policy and guidance, but in the reams of academic and industry research into this form of specialist accommodation, as well as the long list of appeal decisions, some of which you've got before you. For the council, Ms. James repeatedly told us how important it is that people have a choice about where they live. But the people of East Cambridgeshire have no choice. This district's population is rapidly ageing. As we've seen, the number of over 65s will increase by over 10,000 people by 2040, and the vast majority of them own their own home, which disqualifies them from affordable extra care. And against that spiralling need, as you've seen, there's one scheme and no schemes in the pipeline other than this one. In addition, the scheme will deliver critical and much needed affordable housing in a district that's not coming anywhere near meeting its needs. And a range of important benefits will include the freeing up family housing, the provision of almost 9 acres of public open space, which is provision substantially above what's required for the benefit not only of our residents, but for the wider population of Bottisham, biodiversity enhancements and very significant economic benefits flowing from a range of permanent new jobs and public facilities associated with this scheme. So taken all of that together, the benefits described by Mr. Snedden are very substantial indeed. And they clearly outweigh the localised impacts to character and appearance of the site itself and its immediate surroundings. There would, as I've said, be no harm to the integrity of the wider green belt or to its spatial functions. It is very odd, with respect, to see over a page out of 10, 1 page out of 10 total, in the council's closings addressing heritage issues, when, to be clear, all the parties agree that the low level of less than substantial harms clearly outweighed by the scheme's public benefits. You've heard no evidence on heritage because it's not a contentious issue in the case. And even on the council's case, the issue doesn't weigh significantly in the final balance. So, as I said in opening, sir, question at the heart of the appeal is simple. Do the scheme's benefits clearly outweigh its harms? That's it. If they do, then we all agree, or the council agrees, I should say, that you should grant permission applying the balance at 148, the framework. That is, Ms. James accepted the determinative policy test in this appeal. And we do need to be clear about this. Mr. Smythe refers in his closings to, for example, paragraph 12 of the framework. That's fine. But the council accepts, the council agrees that if the balance at 148 tilts in favour of the scheme, you should allow the appeal. Because, in the language of section 38(6) of the Planning and Compulsory Purchase Act, will then be compelling material considerations to justify granting consent. And on that key test, Ms. James, the council, agreed she'd not undertaken an appropriate planning balance in her proof of evidence. That is a very important error. You have, very unusually, a local planning authority agreeing that its evidence has not appropriately addressed the determinative policy test in this case. And with respect, that means that the council's evidence can't be safely relied on, and that's, of course, by its own admission. You must reach your own view. Of course you must. But there's only one set of evidence which applies itself properly to the correct policy test before you, and it is ours. In the end, so ours is a simple case. The benefits our scheme will deliver are very substantial. The need to deliver those benefits is compelling. They'll clearly outweigh what will only be localised harm to this site and its immediate surroundings. And so for that reason, the balance at 148 tilts decisively in favour of granting permission, and we ask you to allow the appeal. Thank you very much.
Thank you very much, Mr. Simons. Okay, so I have one final question, which is, do any parties wish to raise a claim of costs?
Thank you.
No, sir, thank you very much.
Okay, thank you. And just one final, is there anything else anyone wishes to raise before we close?
Say thank you for you all for including me in the process, and it's a shame that we haven't, been able to meet up.
I want to say particular thanks. Obviously, I say thanks at this point with all inquiries, but I wanted to particularly say so in this one because I think a lot of stuff has been thrown at us from outside, and lots of it really quite difficult things to deal with. And I think everyone has dealt with it very professionally and approached it in the right way, looking to find solutions and to keep the inquiry process moving. So I wanted to say thank you to all parties on that. And also a particular thank you to Dr. Keefe, because this is a very alien process for you. And I think you've dealt with it very well. And it's been pretty much seamless, really, in terms of your approach to this. And so, yes, thank you, Dr. Keefe, for your involvement in the inquiry.
Thank you for the thank you.
Okay. Echoed from us as well. Really appreciate it, and the way that both of them, to the inspector, the way that you've handled it, but also Dr. Keefe, the way you've dealt with it as well. It can't have been easy. So many thanks.
Okay. In that case, I'll just confirm. So I'll undertake the site visit on Monday, and then on Wednesday I'll undertake the example visit in Corsham, and I expect to receive the Section 106 by the 18th.
Yes, sir. Yes, certainly.
Okay, in that case, thank you very much, and the inquiry is closed. Thank you.
Thank you. Goodbye.
Thank you, sir.
Bye.
Good day.